All right. It looks like we are live. What is going on, BriHive? Welcome back to yet another BriHive live stream. We are live in the Hive. I don't know if I like only streaming once a week. Like, I feel like I haven't streamed in forever. And I'm trying to get back into the groove of things. But anyways, welcome back to yet another live stream. We have some more nonsense going on in the Bachelor Nation lawsuit. Just kidding. And the Clayton Echard lawsuit, where he was sued by his baby mama, alleged baby mama, for, not wanting to be a part of her doctor's visits because, she was still pregnant, allegedly, or not allegedly. The court found that she was not pregnant. She did not produce any evidence to show she was pregnant. So we have some updates going on in that case. Let me know if you guys have already watched some other people that have probably already covered this. Let me know who you watched and what did they say? What did they think about this? We have Clayton Echard filing his request for attorney's fees, or his memo for attorney's fees right on time, I might add, because he filed it on July 8th at 3 p.m. So they filed it right on the day, probably right before the cutoff for filing was due to be done. So luckily it went through and it didn't get rejected or anything like that, because then maybe they would have missed their mark. And then we also have Laura Owens, the baby mama, was the baby mama to be, allegedly suing, or not suing, but asking to replace the judge. And to say that the motion, and mind y'all, only read a little bit of it, the motion is interesting to say the least. It's very interesting to say the least. And Kimmy, I don't remember, you sent me the link to the rule, but was it the 6.1 rule? I cannot remember off the top of my head, and I didn't have time to look at my last video to remember what the rule was and if we're looking at the same rule he claimed earlier on. Because if we're talking about the same rule, it did not say what Greengrass said it said, okay? It did not say. I don't try to say that man's name anymore correctly. I don't try to say his name correctly anymore. Anyways, let me know if y'all heard about these updates. What are your thoughts on the updates? What are your favorite creators' thoughts on the updates? We're going to jump right into the live stream. We are currently at 15 likes with 29 people watching live. So if you have not hit the like button, please do. It does help us out in the algorithm and helps us get more friends. And we've been getting a lot of friends lately. So go ahead and hit the like button. Go ahead and drop a comment in the comment section, chat section, to let us know that you are watching here live. And if you're watching on the replay, make sure to say hi. I know I'm not really good at responding to those comments, but I see them and I appreciate them. I just don't know what to say back sometimes. Because then I'll type a whole novel, and that's not fun. No one wants to read a novel from Boss Attorney Bri, okay? You barely want to listen to me talk live, okay? Anyways, we'll go ahead and set the like goal for the stream. I'm feeling ambitious, okay? We're going to set the like goal for the stream at 100 likes, so let's see if we can get there. We got 37 people watching live and only 18 likes, so again, if you haven't hit the like button, please do. You know we have a like goal little animation, and Bossy B is ready to do some different things, different than just introducing us to the next topic. I'm going to go ahead and say hello to all the people that are watching live. I don't see if Kimmy has starred anything yet, but we don't have a lot of comments coming in quite yet. So I should be able to get through and say hello to people. So we got Bossy B welcoming us back to the live stream. That sounded really low. Is my little sound low? What's going on here? I don't know what's going on. Okay. Anyways, let's go ahead and jump into the chat. We got Chelsea B saying, hi, everyone, or hey, everyone. Y'all know I can't read. Hey, everyone. I hope the crazy lady has to pay every last cent and then some. I just can't. No, it's not that I can't believe she filed this motion for attorney's fees, but I can't believe she filed this motion for, not attorney's fees, I'm sorry, to change the judge. But I just can't believe she filed the motion to change the judge. And I should believe it. But I don't. I don't think that she's this crazy. Okay. And shout out to Kimmy, because she went ahead and highlighted the document for me. Y'all, I have been in and out of court this whole week and recording some pre-records for y'all. I recorded one. Okay. I'm going to be honest. I recorded one pre-record this week and I'm editing it, and we released one on Tuesday. So if you missed that one, make sure to go back and check it out. We covered, what did we cover on Tuesday? The one where, Samaya Thomas, she pretended, or she was going on a date and then she didn't want to meet the date anymore, and then she called the police. So that's what we covered on Tuesday. And then coming up this week, would y'all like to know what we're covering? We're going all the way back. I'm coming up with some ideas about series, and we're going to talk about it in a little bit, but let me actually say hello to everyone again. Hey to Chelsea B, welcome in. I hope she has to pay as well. Zoe B says she's racking up more legal fees as Clayton lawyers filed a response to Laura's motion to dismiss. Add another $450 to the bill. Did she already file a motion to dismiss too? I thought she only filed the motion to change the judge. Did I miss something? IB93 or 0093 saying hi, hello, and welcome back into the live stream. I also forgot to say Zoe B is a member of the channel. Welcome back into the live stream as well. Chelsea B, you too. I already got this one. We got Zoe B saying hi, hello, welcome in, welcome in. We got Stargazer Kawaii saying hi, hello, welcome back. We got Hella Swanky giving the eyes and saying what's up. Talk about what up, BriHive. How's everyone? Thought you was late. No, it was me. I was late. Welcome in. Nice to have you back, moderator of the channel, Hella Swanky. We got Diana. I hope I'm saying that right. G saying hi. So happy to catch you live again. Well, we are happy to have you in. I'm sorry, I miss going live, but also I like the relaxation, but it's really not relaxation because I'm trying to do other things during that time. Like Kimmy and I had a meeting on Tuesday instead of live streaming, but still busy, but I don't know. I like talking to myself on the camera. And now I feel like I'm talking too much because I didn't get to talk on Tuesday. Does that make sense? I did a pre-record on Tuesday, but it's not the same. It's not the same. Bless my mommy of 4. Hello, welcome back. Saying hi, Bree. Nice to have you in the chat again. We got Berta S saying hi, Bree and BriHive. Hello and welcome back to the live stream. We got Cheryl Reed saying hi, Bree and BriHive. Dropping some B emojis. Hello, welcome back. Nice to see you. We got Cat Lady Ballerina saying hi, all. Hello, welcome back. Welcome back. We got Hey Bell saying hey, Boss Bree. Hello, welcome back. Nice to have you tonight. We got Kimmy Locker saying hello, everyone. Hello, Kimmy the Locker. I am so sorry, Kimmy the Locker. Has anyone ever called you that? Because locker is an actual thing. I don't even know what to describe it as, but it's an actual thing. So you could be like Brianna the rapper or Kimmy the Locker. I don't know. It was all the way off. But anyways, we got Kimmy Locker, our moderator, member, consultant, and paralegal of the channel, doing us a big favor and highlighting the change of judge document for us because the document is really long and I did not have time to review it, y'all. These people in court have been absolutely crazy, but I have to do it nonetheless. And I guess this is how the judge feels in this case, probably. And probably Judge Glanville, I'm not the judge, but Glanville, now he needs to be replaced. But anyways, hello, welcome back. Sorry about that. And shout out to you for highlighting the documents for us. We got Foxy, love the name, saying, love the bees. They make me smile. Welcome in. Nice to have you in tonight. Glad the bees can make you smile. We got Zoe B saying, motion to dismiss judge from the case because Judge Dad watched from overflow room, whatever that was technically called. Yeah, I don't know. It's weird. I have not gotten into the facts of why they're saying that she was wrong, but the one I did get into was them saying that Clayton's expert did not say that Planned Parenthood is not open on Sundays. She did say that they're not open on Sundays, unless I'm remembering wrong, and I thought about finding it in the live stream to see what was said, but I am pretty darn certain that she said it was closed on Sundays, and at least in the Los Angeles area. Okay. We got Jason Swaby saying Locker as in the dancer Locker. No, I don't think so. Kimmy Locker says, nobody calls me Kimmy the Locker, but people hear Walker a lot. So I say like a school locker over the phone and such. Yeah, that's what I think. That's what came to my mind. I don't know. I don't know why I added the in the middle of it. It was a weird thing to do. Okay, y'all. I know I'm really giggly, and I am also drinking wine, but I promise you, I've only had like 2 or 3 sips of the wine, so I'm not lit, okay? So don't think I'm lit. I think I'm just really excited to be back on the live stream. But I am drinking wine, but don't think I'm lit. Don't get me kicked off YouTube, okay? Okay, let's go. We got K Toilet, K-E, or I just don't know my letters. Equality, another member of the channel. Welcome back, saying hi, Bri, or hey, Bri, and hey, everyone. Hello, and welcome back into the live stream. Nice to see you. I completely messed up right after I tried to convince y'all I wasn't lit, and I'm really not. I promise y'all. I'm just excited. I'm just excited to get into this. We got Cynic in Chief. Hello, welcome in. Thank you for the $2 super chat. Definitely appreciate it. Saying, this case is called fatal attraction or tonsil twins. Yeah, basically. I'm glad it was not a fatal attraction so far, but I think tonsil twins is a better series. series for sure. We got Exit Sign saying we watched the thing back and she didn't say that. Did she not? Okay, I could have swore I heard it. Where did we get this information from? Where did we get it? Was it the internet? Did the judge get it from the internet? Now I feel like I need to watch it back. She had to say something along the lines, though, because I don't just go searching the internet for this information. But anyways, whatever. And just because they turned that part over, just because they would have overturned that part, does not mean that she should be replaced as a full judge because she thought she remembered something. You're speculating that she did research, right? You're speculating that. I don't know where she would have got the information from either. Maybe she knows from her own experience. Maybe she tried to go on Sunday. How do you know that? They can use their own experience and common sense. There's no guarantee that she looked it up. I don't care. I don't believe anything Greengrass says. So Cheryl Reed says, I heard her say it too, Bri. Apparently we are wrong. Widget 81 says, well, it could have been in other filings or her report too. Yeah, that is also something that could have happened. So, Kimmy, are you able to find when this doctor goes on into her testimony so we can watch it back really quick and we'll watch it on a little sped up? Because I know she said something along the lines that they're not open, or maybe I'm on the internet too much. The realization of maybe I'm on the internet too much. Yeah. Thank you, Kimmy. Kimmy, not the locker. Get it together, Bri. Let's see. Which 81 says, why wine? It's free Slurpee day. I didn't know that. I did 7-Up. Y'all, this is going to sound embarrassing. When I was at work today, I was like, 7-Eleven, that sounds like something that's important. Like I should remember that date. And you saying that is Widget 81 saying that it's Slurpee day? Was my brain subconsciously trying to tell me that it's an important date because it's Slurpee day? I think it was. I'm going to have to go get a Slurpee. But you know what? Like towards the end of the day, all the Slurpee machines break. So I should go get a Slurpee. I can drink wine and Slurpee, a Slurpee wine maybe. Stargazer Kawaii says, it wouldn't be wrong if the judge did look at the dates and hours of Planned Parenthood online. Yeah, and that seems like research. Like the case that they compared it to was the judge making comments on like Facebook. So I don't know, because judges are allowed to do research, okay? They're not allowed to, go find facts of the case. But whether Planned Parenthood or not, was open or not, I don't know if that's necessarily I think that's something you could research versus it being a fact of the case. And whether it came in as testimony, I don't know. I want to watch it now. Exit Sign says, we don't know if it's anywhere in the other documentation, though. Also, that one fact doesn't change the result of the case. I think so, too. She didn't rely on that to make her finding. It didn't say that she never went to Planned Parenthood. I don't think that was in the finding. So I don't think that specific fact would turn over her being the judge. That's my opinion. So I agree with Exit Sign. Widget 81 says, fetal attraction. Oh, that makes so much more sense for the case. Yeah. Oh my gosh. Yeah. Okay. That's a good name for it too. Equality says, Fetal. Okay, got it. Thank you. CE says, Dr. Dion did not mention closed Sunday while testifying. Who did that? Someone did. They had to. I am not willing to believe that I got that information from the internet and I ran with it. Or maybe it's because I read the judgment, the decision. Maybe the judge has changed my mind at this thing. Yes, free Slurpee Day is a thing at 7-Eleven because 7-Eleven serves Slurpees. No one else serves Slurpees that I know of. It's a thing. It is a thing. They're like the little ones, though, that are free, but it's still free, okay? Stargazer Kawaii says, Megan Fox looked up a court ruling that said judges can look online information of common knowledge. Yes, that. And I agree with that. It's not necessarily trying to find a fact of the case like, oh, I forgot what the defendant's birthday is. Let me look up the birthday. That's a different story. Let me see if he ever posts pictures of bikinis on his Instagram. That's a different story. But common knowledge, that does make sense. I'm not familiar with the rule on top of my head, but judges are allowed to research. Island says, hey, BriHive, hello and welcome back. Nice to have you in tonight. We got Kimmy Locker saying Planned Parenthood being closed on Sunday was definitely said in our chat. I know it was in our chat. I know it was also in the judge's ruling. I agree with Greengrass on that, and I don't agree with him on a lot of things, but I'm trying to think if it was said in court or not, or if we just talked about it. Stargazer Kawaii says comment sections for which one? Cheryl Reed says they're looking for anything to overturn. In my opinion, it's a long reach. I agree, and I don't think that was a turning fact in the case, right? I don't think so. Exit Sign says there was thousands of us in the live stream. Yeah, we were, and we thought it was sad. We thought it was sad. It's okay. It's okay. Okay, Kimmy's looking for that part of the case for us to see if we're wrong and we're all just, having I was about to say Streisand effect, but the Mandela effect. Maybe that's where we are right now. In a different universe, it was said during the trial. Anyways, y'all, let's go ahead and jump into the first document, which is the attorney's fees, which we're not going to cover very much, but I would like to ask, and right after Bossy B brings us in to the next step of the live stream. Let's go, girl. Okay, I would like to ask if you guys would be interested in me and or Kimmy or both of us going through the charges on Clayton's bill and pointing out the most interesting charges or the highest charges or whatever you might be interested in. Do you guys think that would be a good idea? Go ahead and drop a 1 in the chat. If you don't want to care what the most outrageous charges were on his bill, whether they're funny or they're high in cost, drop a 3 in the chat if you don't care to see that. But if we're not going to do it today, it'll probably be a pre-record if anything. But let me know if you guys would like to know what the most outrageous charges are, because this document is like 65 pages, okay? We're not going over all of that today. And again, if you haven't hit the like button, please do. We're at 51 likes and our like goal for the stream is 100. We're halfway there with 77 people watching live, so I know we can hit our like goal, y'all. I need to get like a little thing that goes in the background that says like goal this much, blah, blah, blah. I don't know. That's what I need to do, though. I need to do that. Okay, so let's go ahead. I already did Bossy B. Let's jump into the application for attorney's fees by Clayton. Like I said already, I have to actually add the document to the stream, Bree. Okay, there we are. Like I said, they filed it on 7/8/24 at dang near 3 p.m. A lot of courts close or their filing closes around 4 p.m. I don't know exactly what the cutoff is in this particular court, but they filed it, in my opinion, at the very last minute. Now, granted, it could have been filed at like 3:59, but this is pretty not sketchy, but dangerous in my opinion, because if it got rejected for any reason because you didn't check the right box or whatever it may be, he could have missed out on getting his attorney's fees. But I also know that it takes a long time to get together 60 or 50 pages of billable things that only relate to this particular instance, because not this particular instance, but particular things, because the judge did say that they cannot get attorney's fees for different things. Okay, so we are bringing it back to the matter of Laura Owens and Clayton Echard. This is the application for attorney's fees and costs. So why are we here? We are here because the court said that Laura's behavior was so bad that she needs to pay Clayton's attorney's fees for making him come to court and argue that he was not the pappy, okay? He's not the pappy. You, Clayton Echard, are not the father, and we don't really know whether Laura Owens was ever pregnant, but I digress. This is for the respondent, Clayton Echard, by and through his attorney and pursuant to the minute order in the ruling on June 17th. And it's filed and entered with the clerk of court on June 18th of 2024. blah, 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 with the rules of procedures. They're filing this because the court said they can file it, okay? After the evidentiary hearing on June 10th, 2024, on the issues of non-paternity, sanctions, and attorney's fees, in which the court had the opportunity to consider the parties' papers, arguments, and evidence presented, the court ordered in pertinent part as follows. Ooh, maybe we do need to go through the document because they're saying that the court considered the papers, which makes sense. It didn't really seem like she relied on it that much, but also we didn't know that she went to the Los Angeles Planned Parenthood during the pretrial briefs. We found that out in court. So maybe I'm just like confusing myself a little bit. We're going to look through it. We're going to look through it and see if we can find it. Okay. So the court further finds, okay, they basically say that, what's her name? Laura acted unreasonably, is kind of fraudulent, all of the things, right? And then they granted him the attorney's fees. Let's see. On the court's own motions, they found that Laura knowingly presented a false claim, knowingly violated a court order compelling disclosure of or discovery, such that an award of attorney's fees and costs is appropriate. They are granting Clayton Echard requests for attorney's fees and costs associated with this case number here. They're also awarding they're denying attorney fees as it relates to the order of protection and the, the intentional, I forget what the I stands for, but the harassment hearing as well. They are ordering Laura to pay reasonable attorney fees and costs not later than July 8, 2014. Respondent, as in Clayton and his counsel, shall submit all necessary and appropriate documentation to support an application for an award of attorney's fees and costs, including a China doll affidavit and a form of proposed order. No later than July 29th, Laura Owens shall file any written objection and a form or proposed order. If Clayton Echard's counsel fails to submit documentation by July 8th, 2024, no fees or costs will be awarded. The court shall determine the award, enter judgment upon review of the affidavit as well as any objections. So Clayton has filed his documents. Laura now needs to file her objection if she's going to do that. And then the court will make a determination. Does not sound like it's going to actually be a hearing to determine the fees. They're just going to look at the paperwork to determine how much Laura Owens is going to owe to Clayton. So that's good. Like I said, Clayton almost missed his chance to get some attorney's fees, okay? This application for attorney's fees and costs is based upon the affidavit of Greg Woodnick attached as Exhibit B. And then there's also some other things and some itemized billing. What do I want to call this? Itemized billing. It just call it that, Brie. Itemized billing. It goes through every single nick and cranny that Clayton was charged for throughout this case. I cannot see how any of them had any other cases during this time. Although maybe it was not, their charges aren't happening like every day, so I guess they could have other cases. But why is every single one of these people working on the case? He had like 6 attorneys on his case and a law clerk and a couple of paralegals. Absolutely ridiculous in my opinion. It's a big case, but it wasn't that big of a case. It was a 2-day freaking trial. I don't think you needed 6 attorneys on the case. Sorry, Clayton, I'm not on your side with that. Think you would have been fine with 1 because I do it as 1 2-day, 3-day, 4-day trials. I do that as 1 person. Me, little old me, I can do it as 1 person. So I don't agree that it should have been this many attorneys on the case. Sorry, I'm hating on you for that. I know. I am. I'm not nice. I'm not nice for that one. Is it this one that's low? I don't know which one's low. One of them is low. Or maybe my hair is just big and then I can't hear. Anyways, I don't support them on the 6 attorneys. It might be a little less than 6 or it might be 6. I don't know. Too many attorneys on the case, in my opinion. I know it's high profile, but it was a 2-hour trial, bro. It was a 2-hour trial. Let's see. He's going to tell us about how much they charge. We got Greg Woodnick being the first duly sworn upon oath, deposes and states as follow, that I am the managing attorney at Woodnick Law, PLLC, and together with Deandra Arena Esquire and Isabel Ramney Esquire, we are the attorneys of record for respondent, Clayton Echard. Again, I don't think you need 3 attorneys on a paternity action. I don't. But also there's a lot of moving parts in this case, so I can see why they had multiple people at the table. That I am a citizen of the United States over the age of 18, and he makes the affidavit based on personal knowledge. I am competent to testify as to matters as addressed herein. That myself and all attorneys involved are licensed to practice law in the state of Arizona, I was about to say California. That in light of the highly contentious nature of this litigation, amplified by petitioner alleging that one of the attorneys at this firm was complicit in SA, the office instituted a policy requiring the presence of a second professional during any interaction with Ms. Owens or her numerous attorneys. Crazy, because she wanted to say that Woodnick was groping her low-key. They had to hire like a police or a security or someone to stand by while all of this went on. Okay, the next exhibit B is the fee agreement entered into by Clayton Echard with the Woodnick Law PLLC law firm. The fee agreement is based on an hourly fee rate, and they go ahead and let us know what the rates are right now. We got our guy, Gregory Woodnick, billing at $650 an hour. That's a lot of money. Mind you, he is very experienced. He's going to get into him having several years of experience, but $750 an hour, that's a lot of money. You talk to him for 1 hour, boom, there's $750 or $650. You talk to him for 6 freaking minutes, $65. $65 for 6 minutes. It's like $10, more than $10 a minute. It's a lot of money. Attorneys charge a lot of money, and that is a lot of money. Okay, and then we have Attorney Deandra Arenas. Billable rate is at $425 per hour. I'm wondering if they increased their hourly rate for this particular case, because it's the cost of living in Arizona that much to where their attorneys' billable hours need to be that much. Let me know if y'all live in Arizona. Is the cost of living that high there? These are like California numbers. These are they're like $425 in my area, and we live in we work in the area where we got $1 million houses on lakes, all kinds of stuff. We live over there, and that's top dollar, one of the top dollars of attorneys in this area. So is Arizona really that high cost of living? I didn't think they were, but maybe they are. Top dollar for the second chair is top dollar for California. And I don't know about LA. I don't live in the LA area, but we live in a pretty expensive area. I'm just shocked about their billing rates in Arizona. And maybe I'm wrong about what their cost of living is, but that is very high. It's very high. We got Marcus Reisinger billing at $425. Attorney Isabel Rainey billing at $295. That sounds more like Arizona. That sounds like more of Arizona hourly bill rates to me. I don't know. I don't practice in Arizona, but that sounds more appropriate to me. And she sounds like she's more one of the newer attorneys. Okay. The firm employed multiple paralegals and BSSEP who provided assistance in the matter as detailed herein. Paralegals bill at $175. They employed one law clerk who bills at $175. The total funds that have been expended on this litigation is over $165,000. This case lasted less than a year, and $165,000 you could have sent somebody to school. You could have sent him to law school. You could have sent Clayton to law school himself. Okay, you know what, Laura? You might be sending Clayton to law school at this point with this bill. Okay. Okay. However, fees that were related to the litigation of respondent's injunction against harassment, that's what it's called, have been excluded as the court expressly denied attorney's fees and costs related to that matter. All attorney's fees and costs included herein were necessary and reasonable. I don't know what, Nick. $650 an hour in Arizona. Please correct me if I'm wrong, y'all, in the chat. But that's a lot. That's a lot. Even for the most experienced. Okay. That the court should note that early in litigation that Mr. Echard received assistance from GoFundMe. These limited funds were appreciated by Echard, but only covered some of the expenses and costs related to Echard's injunction action, which has been expressly excluded from this accounting. The GoFundMe proceeds did not contribute to Mr. Echard's legal fees paid, incurred, or actually due and owing in this matter. I wonder how much of this he actually paid. Like, what is his bill looking like at that firm, or is he at a zero balance? The fees and costs incurred in this matter through Whitnick Law PLLC are as more specifically set forth on the invoice for professional services, which is attached to the application for attorney's fees and costs. The respondent has agreed to pay and has been charged for said services at set rate as documented in the 2023 fee agreement. Again, I mean, I know they knew it was a high profile case. I want to know if this is always their hourly bill. I have to know if this is always their hourly rates. That the bill and timekeeping information related to this matter was documented utilizing regular billing software in the ordinary course of the firm's business and accounting practices. That all of the items related to bills associated with counsel's time therein were made and kept entirely in the normal course of the firm's activity on this case based upon time records kept by the person generating the activity at or near the time the service were performed pursuant to the regular practice of this firm. That all of the items related to bills associated with counsel's time are true and correct, and each was necessarily expended in the course of litigation of the scope specifically identified by this court in the June 17, 2024 ruling awarding attorney's fees and costs. The affiant Greg Whitnick has been practicing law in Arizona for 24 years. He is the co-author of Family Law Attorney's Fees Survey. Well, I mean, I guess he knows how much he should charge in attorney's fees because he wrote the book on it in Arizona, apparently. Is the current chair of the State Bar Client Protection Fund. Okay, so he knows about how much he can charge. Is cooperating counsel to the ACLU. Was previously appointed by Chief Justice Bell to the Arizona Supreme Court Task Force on the Arizona Rules of Family Law Procedure, is a former adjunct professor, is a graduate school lecturer, current and former, Sandra Day O'Connor College of Law. He goes out and lists a bunch of different law schools. We are not going to read all of that. Is a CLE instructor in Arizona for the Children's Service Network, for Maricopa County Bar Association. He's all up in it, okay? He's teaching people how to be attorneys. He's writing the rules on fees, and that's why he got the super high fee. We got Deandra M. Arena. Why do I want to call her Marina? Arena is a former assistant attorney general for protective services. Interesting. Is a licensed to practice law in both California and Arizona. Girl, is this your normal billing rate? Let me know. It's California billing rates, y'all. Is an adjunct professor. Marcus Resingner is an adjunct professor of administrative law in the MLS and MHREL program at Sandra Day O'Connor College of Law. Is cooperating counsel to the ACLU. We got Isabel Ranney. Okay, 4 attorneys on the case. I said 6 earlier, so please correct me. Is an attorney associate at Whitnick Law, and she was also a law clerk there. That all the attorneys, paralegals, law clerks, and staff involved in this matter are duly qualified and experienced, commensurate with their respective hourly billing rates, and that the rates agreed upon and the actual charge are customary and consistent with the prevailing market in the legal services of this kind. Blah, blah, blah. He goes on to say that they expended an additional 1 hour using Whitnick's time to generate this China doll affidavit, which is insane to me because it's like 60 something or 50 something pages of just billing, and that only took you 1 hour to do, Whitnick. I don't know, because you would have had to go through every single one of the charges and make sure that it was related to this and is appropriately being charged, because sometimes you might bill for something and realize, oh snap, I shouldn't have billed for that. Let me take that off. But going through all of these charges, 40 to 50 pages of charges, and you're telling me you only took 1 hour to do it? I don't know, Nick. That's like 1 minute per page. 1 minute per page. I think that's a little bit too quick. I probably would have billed a little bit more for this preparation. Let's see. And then also write, or maybe he only charged for writing out the document versus actually preparing the billing. Maybe that's what it is. They go on to say that they spent $148,816 just in attorney's fees. Then we have another $650 for the cost of this China doll affidavit. And then we have another $4,776.76 for the total cost of the court and expenses. Then the total is $154,242.76. Laura, I think you should just come, if you want to give out $150,000, just come and pay my law school, bills. Just come and pay that. It's a way better use of your funds than paying to try to convince someone that he's your baby daddy. Way better use of your funds. Okay, and then so in the fee agreement, what I thought was outrageous, we're not going to go through all of this. What I thought was outrageous was the fact that they are only charging, where is it at? They are only charging $4,000 retainer. Sir, you're going to use up that $4,000 retainer in like less than 10 hours using Woodnick's freaking hourly bill, his hourly fee. Maybe that's why I thought there was 6 attorneys, because there's a bunch of attorneys listed here with their hourly rate. But seriously, $4,000 retainer? We charge freaking $5,000 retainer, and our hourly rates are under $400 an hour. You're running through that $4,000 retainer. I can tell you that. And you know what that also signifies to me? That also signifies to me is that their hourly rates, okay, their hourly rates are probably not normally that high. And that's just my opinion. I don't know. I never tried to hire them. I don't know what their hourly rates are, okay? But a $4,000 retainer signifies to me that their hourly rates are probably more around $300 an hour and lower. Okay. That's what it signifies to me. I could be wrong. I could be completely wrong. Around 300, max 400. And so the way that these documents are written, you can just change what the hourly rate is. But the fact that they didn't change this retainer is suspicious to me. It makes me think that their hourly rate is a lot lower than these ones right here. And they could have agreed to it then because it was a high profile case. In certain cases, they require a little bit more work. So of course you can always change your hourly fee, but that retainer is giving it away to me. Correct me if I'm wrong, Woodnick. Sorry, I might be spreading rumors, but that's just my opinion. It's just my opinion, y'all. Y'all can let me know what y'all think about it. Do you think that signifies anything to you? And then the other thing that stuck out to me in this fee agreement is that this agreement specifically excludes going up on appeal to any federal or state court of appeals by any party. Why is that? Why does that stick out to me? Because Greengrass got on the Beyonce's internet. I don't know if we want to call it Beyonce's internet, but we got on Beyonce's internet and told us that Woodnick is not going to win on appeal because he's never seen him have a successful appeal. And we talked about it on a previous live stream. As a trial attorney, a state litigation attorney, you do not have to do appeals. This paragraph lets me know that they probably do not do appeals in this law firm. Okay? Otherwise, it wouldn't be in their fee agreement. They can say we can meet and confer to determine whether we will take it up on appeal. This agreement does not include it, but our office does provide the services in so many words they can indicate that. But this indicates to me that they don't do appeals. So you're not going to hear that Woodnick was successful on an appeal because he does not do appeals. Again, not including appellate issues. Okay? This scope is limited and dependent on funding. Sounds like they kept working on his case before then. Oh gosh. So anyways, those are things that stuck out to me regarding the actual fee agreement. I'm not going to go through and read all of that because it is what it is, right? Let's see here. Tells them to keep all of his documents. They can terminate the agreement at any time. Clayton signs it. And then we get into the billing. And y'all, I am not going to go through each of these billings one by one because it is ridiculous. I can definitely probably do, and I know I asked y'all in the chat, but I've been running my mouth since then. I can probably do a review of like the highest charges or the most outrageous charges, the craziest charges, like maybe charging for the security guard for Laura Owens. Maybe that's listed on there for us. But see, we got a 1 hour meeting with Woodnick, $650. There was one that was like $3,000. Where did it go? It's just like, look how quickly these things add up. We got 170, 295. We got 52, 88. We are finalizing drafts and drafting and revisions and emails and calls to Laura, newest attorney. This says calls to Laura, newest attorney. Because she had so many attorneys throughout the case. Oh, I caught her newest attorney up. That's wild. You could have just put to her attorney. You didn't have to put the newest attorney. I haven't even looked through this, y'all. I just saw like some of the numbers and was like, this is ridiculous, right? Okay, so I'm gonna go ahead and jump into, dang, there's a cancellation. It took you 18 minutes to cancel an appointment with a videographer? And drafting a letter to opposing counsel. Okay, that makes sense. The spoliation letter to Amazon. Okay. Anyways, I can go through it and see what are the funniest ones or the most outrageous ones, and if y'all are interested in covering that. So Kimmy went ahead and found where the testimony started for Clayton's expert. So we'll probably check that out. I don't remember how long. It was probably like less than 20 minutes. We'll watch it on a little bit sped up, but I do want to get through some of the chats before we get into that. So let's have Bossy B bring us in. All right, y'all. So let's see what the chat has to say about all this nonsense going on here. We got Exit Science saying Greengrass. Yes, it's Greengrass. I'm not going to try to say that man's name right because he is ridiculous. Okay. Boots on the Ground says, my biggest surprise was learning of another attorney she had. I think she had like 3 though. Exit Assign says, I'm curious about the one that said no charge. Why would that be? I didn't see that. I did not notice that, so I'll have to go back and check it out. We got IB0093 says some eyebrow raising descriptions. Are we talking about for what? I get so distracted, y'all, and I'm like far into where these comments came from, so please forgive me if I forgot what I was said. Widget 81 says it's 5 p.m. We take filings till close of business. Okay, are you in the Arizona courts? I know in our courts they stop at like 4. Like no more, we're done. Go, goodbye. Zoe V says, I wonder if they filed closer to the deadline to ensure they covered everything, including Greengrass. Gringas. I really just changed his name. Gringas shenanigans right up to the deadline. Probably. Coach Karen says Maricopa County filings is by close of business day, 5 p.m. Monday through Friday, except major holidays. Okay, thank you. That makes sense. Widget 81 says injunction against harassment. Okay, that's what it stands for. I always forget. I'm still gonna forget. I promise you guys I'm gonna forget again. Hello Swanky says, for those just joining us, don't forget to hit the like button. Oh yeah, don't forget. I have not checked our like goal, but our like goal is 100. If you haven't hit the like button and we're not at 100, or no, you know what? Even if we're at 100, go ahead and hit the like button. Help us out in the algorithm, get more friends. We definitely appreciate it. On the Ground says, dealing with Laura Owens, I think all the attorneys are needed. A lot of attorneys. There was 4, so I guess it's not as outrageous as I originally thought. But 4 is a lot. But there was a lot of moving parts in this case, so I agree. Okay, I'll take it back. Exit Sign says most of the work was done early on by Isabel, though, which is good because she was the one with the lowest rate, right? We got Stargazer Kawaii saying 6 attorneys is excessive, but she does have a lot of history. That is true. That's why I said I'll take it back. We got Zoe B gifted 1 Boss Attorney Bree membership. Thank you very much. Yes, we appreciate it. I need to get a better audience sound. I don't like their audience, but thank you so much, Zoe B. Definitely appreciate it. We got Sora. I hope I'm saying this right. Sora saying, I think they had so many lawyers because they were building the case for more lawsuits. Yeah, it's probably going to go on to more lawsuits. But what I did notice about the fee agreement for Whitnick's office is they do appear to be a family law firm based on some of the language that was in the fee agreement. So I don't know if Whitnick will actually represent him in any civil suit that he files. Coach Karen says most firms won't file until deadline in Arizona. They don't give room for a counter response is usually why, but she still has a 20-day response anyways. She has until the 29th to respond. But my concern would be like if it gets rejected on accident, which I guess if you're a good law firm, your filings are not getting rejected. So I guess that makes sense. Exit Sign says also apparently because she accused Woodnick about bad stuff, they had multiple people in the room with her. Yeah, we did read that. Island became a member of the channel saying or I think Island was already a member. Well, either way, member of the channel saying, yeah, she accused Woodnick of drugging her and trying to SA her. Yes, I do remember that in the Gillespie case, right? We got Boots on the Ground says she accused Woodnick of grave. Yes. Avid Reader Red says lots of attorneys, but Woodnick was his main lawyer and had the highest rate. The other attorneys did work at a lower rate and save time. Now, that is not true in my opinion, because guess what? If Deandra is having a meeting with Woodnick and Isabel, they're all charging their hourly fees. So their rate, if those three are talking about the case for 6 minutes, let's see. I can do it like that, right? 60. Okay, no, I'll do it like this, Bri. $65 plus how much was Homegirl? 42 or 425 was Deandra, plus what is her name? Isabel was 295, right? So you just spent 137 minutes because those three were talking to you or talking to each other, okay? And then if you go ahead, I guess I could have just times it by 10, but here we are again, Bree typing out the numbers, plus 295. If they have an hour meeting with Clayton, getting ready for trial, $1,960. You spend almost $2,000 from talking to your attorneys for 1 hour. So it doesn't really save you money. What will save you money is if, okay, Isabel does this and then she, writes up a report. And I guess you can make it a lot less time because Woodnick just reviews it and maybe it only takes him 6 minutes for something that took her 3 hours to do. I guess it could save you money, but debriefing and all of that stuff adds up fast. That's one thing I hate about billing is like if I'm having a meeting with the other attorney, like I don't like to charge them for both of us. Don't tell my boss that. Cheryl Reed says, why am I not surprised by her accusation? Seems par for course. What? Seems par for course. I don't know what you mean by that. Isla says she did this to herself. She sure did. Oh, I'm saying more of if Clayton had to pay it. I don't really care if Laura has to pay it. I don't. Equality says the trial was only 2 hours, but there were many, many motions before that. Yes, no, I agree. I definitely agree, but I have to do it all by my freaking self. Okay, so maybe I'm just hating. Okay, Island says multiple hearings, at least 3. Island says, and she threatened to sue Clayton Echard for $1 million. Again, I don't think that Woodnick's office will handle any civil lawsuit outside of the family law. Based on their fee agreement, they could practice other areas of law, but from my reading of the fee agreement, it seems like they practice family law. Avid Reader Red says Woodnick was the main lawyer and had the highest rate. The other lawyers and staff did work at a discounted rate and saved money. I agree with that, but I think those are higher rates than they normally charge. I'm sticking to it until someone can prove me wrong. Until you can prove me wrong, I'm sticking to that's higher than the rates they normally charge. Boots on the Ground says the Scottsdale's attorney, this is what you pay. Okay. So we got maybe cost of living in Scottsdale. That's the high rate. Widget 81 says Woodnick, the priciest, need Deandra for the way she questions. Laura Owens and Isabel is the writing genius. That is good. I'm not saying he doesn't need all of those attorneys. This case did have a lot of moving parts. Like I said, I'm probably just hating because I would have to do it all by myself. Coach Karen says I'm doing Scottsdale in is the Hollywood of Arizona. Okay, makes sense. Okay, y'all proving me wrong. Leanne saying Scottsdale is expensive. Got it. Widget 81 says I am in Arizona. Cost of living is high cost. Okay, I was wrong. Cheryl Reed says Scottsdale is very expensive. Okay. Widget 81 says 1-bedroom apartment is $1,600. Okay, so that's about, I think ours is a little bit higher in the area that I live in, but that's close enough. Cat Lady Ballerina says Laura could have bought some baby at that price. That's so wrong. I shouldn't be laughing. I should not be laughing. It's wrong to sell children, okay? But she definitely could have bought like a good, how many children she could have got like 5 or 6, low key. That's wrong. I'm not even gonna go there. I was gonna make a joke, but that's not funny. Boots on the Ground says Woodnick is cream of the family law crop in Arizona. Okay, y'all prove me wrong. I'll give it up. I gave it up. Avid Reader Red says they were pro se for a portion of time. The lawyers came in around November 2023. Yes, and so yeah, I said less than a year, but they were really on the case for maybe like 8 months or less than that, right? 6 or 7 months. Boxing for Life says she's going to be responsible for Clayton's fees, her attorney's fees, the appeal fees, and previous lawsuit. Just burning her dad's money. Like, why? Just let it go, girl. Just let it go. Let it go. Island says Whitnick represented one of the other victims of Laura. It's personal for him. He's likely not been paid much yet. That's what I'm thinking. I don't think that his account is at zero balance. He probably owes $100,000, if not more, right? Exit Sign says, I bet they will settle with Clayton or take a cut from the defamation suit. Let's look up Whitnick's law firm. Whitnick PLLC. Okay, people are searching for my guy. Let's see what kind of law he practices. Okay, let me bring this out. Bring StreamYard back over here. Bring the website up here so we can, what kind of law? Come on, what are you doing, dude? Leave it to Bree in the technical difficulties. So let me fix my screen here. Stop screen, share it again. And then we are going to look at Woodnick's website. Lovely website. Okay. Lovely website. Let's see. Practice areas. Yep. Okay. They are a divorce attorney. They do child protective services, family law, consulting with crisis management, criminal defense, domestic partnership, same-sex marriage. That's when family still, grandparent visitation, juvenile crimes, professional licensure, and community. What is community? Reporting compliances and all kinds of stuff. So majority, they are a family law firm. They're not going to file her motion for, his motion for defamation or anything of that nature. If she would have sued him for the whatever she was trying to sue him for, they would not have filed that case. Most likely would be sent off to someone else. I can't think of words today. I'm like using really bad words. I'm like speaking like a preschooler at this point. They'll send it to someone else. They'll refer it to a firm that actually practices that kind of law. They are more along the laws of family law. You will see some criminal attorneys doing some family law type stuff, but as you can see, you don't see any like civil practice, defamation, torts kind of situations. So yeah, they probably will not represent him for that, but they're creating a good record for whoever comes to pick up the case afterwards. And this is a picture of all of the lovely attorneys that they have there. Lovely, 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 nice. Okay. And then here's some support staff. Lovely. I don't know why I'm showing these pictures. I think SS was one of the paralegals on Clayton's case. Anyways, let me get off these people website. But anyways, yeah, they're probably not going to help him in any civil lawsuit that he may have coming up. So let me get out of there. Let me bring myself back over here so I can read these chats. We got Widget 81 says, I know my education law attorney for my son is $485 an hour here in Arizona. Okay, I guess I was wrong. I thought that was high. I thought it was high. I'm loud and wrong. Loud and wrong on the internet is wild. Joe Reed says lots of credentials. Yeah, definitely. Catherine Imhoff, I hope I said that right, says, Bree, what kind of bond is required for an appeal in Arizona? I remember it's 100% of the award amount in Virginia. I have no clue. I don't practice in Arizona. I could probably look it up, but I probably wouldn't be. I don't know if y'all want to rely on my Google searches today. Zoe B says, I bet they closely tracked all charges from day one to ensure they were ready for this outcome. Yes, no, it's not even that, right? This is literally how law firms make their money. Literally, you open an email, point one. You should read it too. Don't just open it and then charge it for reading it. Don't do that. But you open it, you read it. Most emails are probably a 1 minute read. You're charging 6 minutes for it. Easy. And that was in their a fee agreement. We can look at it. They bill in 0.1 increments, 0.1 of an hour, that's 6 minutes. So even if they only took 2 minutes or 3 minutes to do something, you're getting billed at 6 minutes. If they took 15 minutes to do something, you're getting billed at 18 minutes. I know these off the top of my head because I have to do this every freaking day. So that's how hourly billing attorneys bill. They're tracking everything. Email from so-and-so regarding this. Client called to tell me that they lost their socks. You're getting billed for everything, okay? I don't know where I come up with these examples. Lost your socks? Why are you calling me for that? They do call you for weird things. I'm not going to lie. Boots on the Ground says, 15 years ago, my legal advocate for my son was $250 an hour here in Arizona. Kate P says, depends on the time tracking software, as I worked at an accounting firm and we had to record our time very, very specifically by every 6 minutes. And it was easy to pull time reports of any configuration. That is true, but maybe I'm comparing it to me because normally when I go through it, we put it like this to me, and maybe they're using a different software. That's not how the bills print out. Maybe they designed their bill different. Let me not judge, okay? We literally don't use our bills because some of the bills have confidential information on it. So whenever we do any time reporting to the court, we put it onto like a letterhead document versus our actual billing documents. Because otherwise you'll be printing a bunch of bills and it might have some stuff on there that doesn't need to be on there. Then you'll have a bunch of like redaction lines on there, and we don't like to do that. So just depending on that does not look like it came from a law firm software to me. But potentially their law firm software is different than ours. It looks like it's put on to a Word document, which is normally what we do. Exit Sign says she could have just like bought a surrogate and a few horses. Yeah, get a freaking surrogate and then ask them for Clayton's sperms. Don't do that. Don't do that, Laura. Don't get any wild ideas. Island says, I suspect their normal retainer is higher. The retainer is not normally something that you reduce. If anything, it's the hourly fee. Because once you go through $650 4 times, you're already more than halfway through that retainer. So maybe it's normally higher. And the fact that it's set for trial, it definitely should be higher, in my opinion. But to me, that reflects that maybe it's a lower hourly rate, but maybe the retainer, the common retainer in the area is low like that. I don't know. Maybe. I don't know. I'll shut up. I've been proven wrong, so I'm just going to be quiet. Okay. Boots on the Ground says, I think they gave him a break on the retainer. That they would have had to. Equality says, I think the low retainer is them being courteous to Clayton. I wonder if they usually charge higher retainer. But my thing is, why are they being courteous to Clayton? Because Clayton makes $120,000 a year. Or $140,000 a year, whatever it was in the in one of the documents. So I don't see why they would go, like, maybe if someone's making $60,000, no. If they were making like $30,000, I could see someone dropping a retainer. But Clayton making like $12,000 a month, why are we dropping a retainer for him? I'm sorry, Clayton, not trying to hate on you, but I don't know. They can charge different retainers, but for something that was set for trial, that's a really low retainer in my opinion. Kimmy Locker says, my probate attorney was $300 an hour, and I think the retainer was $2,000. That makes sense because it depends on how much you had to do in your probate case. It may not have taken a lot to get started, but with something like this that was already set for multiple, he had already been through a hearing and then it was set for trial, $4,000 is really low. And then they would have to review all the nonsense that, what's her name? Laura dished out at them. Coach Karen says to Kimmy Locker, that's cheap. Mine was $10K to handle a simple estate. Dang, that sucks. $10K for this. That's high. Now that is high. Kimmy Locker says to Coach Karen, gotcha. My total was definitely way more than that, but maybe I got a break on the retainer because my corporate attorney referred me. I do see, probate attorneys charging lower retainers in my area too. So that might just be common practice for them. South Florida Thrifter says, oh yes, fun attorney breed coverage of this case. Thank you very much. Boots on the Ground says they repped him in 2 other cases with her before this one. Which 2 other cases did they represent him in? I didn't know he had other cases with her. Boots on the Ground says, I think it's fair to say newest to prove Laura Owens did things to drag out the cost. Oh, for sure. For sure. And that's why she needs to pay for it. Leanne says there's a communication with Gringas that states she might be mentally diminished. They said that she has mental health issues. I haven't seen the mentally diminished issue. Widget 81 says Woodnick recently took a case on appeal, but it ended up settling, but you can find it on the Court of Appeals website. Nice. Widget 81 says the charge for the call with Gringas saying Laura Owens has mental health issues. Is that on there? Did it say that? No. You know, why y'all get me distracted in the chats? Like, I don't understand. I get so distracted. Did it say that? Can I control find on this document? Control find point to. Okay, yeah, I can't. Let me see. Mental. Oh, no, supplemental. Okay. I thought I found it. Okay, let me show y'all because I didn't mess things up. Share screen. Window. Boom. I need to stop messing with my settings in the background and not knowing what I'm doing. Okay. The supplemental. I don't see it. I just see supplemental disclosures. Okay, here we go. Ooh, good one. Email to Clayton. Then we got email from Gringas. Staff for draft response. Sat in on a call with DG. DG believes texts with MM are likely real. Laura is considering her own expert to review MM laptop. DG is trying to get Laura to agree to a settlement, possibly an underlying mental health condition. Notes on same staff with GW and DA. So had a meeting with Woodnick and Deandra after sitting in on a call. And so look, she sat in on the call and then charged her time. Gringas charged his time. And I don't see that, what's her name? Andrea charged her time. Maybe she didn't. Okay. So, but yeah, you see? Oh, when you're saying that it's she didn't charge her time. So they're saying no charge because they didn't charge him for it. She billed for it, basically made it non-billable because she was just sitting in and listening to it. But technically, they could charge for all of them being in that room. So that someone asked earlier, what's the no charge? That's what it is. They basically are not actually putting it on his bill. But what's her name? Isabel still gets to use it as her billable time for the day, if that makes sense. But yeah, I see mental health condition. To me, that could mean mentally diminished, but it also could mean that she just has mental illnesses, which doesn't necessarily mean that she can't think for herself. So I don't know if I would consider it mentally diminished, which I think she admitted that she was on some psych meds. So there's that. Widget 81 says, yes, I'm in Arizona courts. Okay, cool. We got Cheryl B saying she's truly horrible. Hopefully she stops, but she won't. And we have a whole nother document talking about her. Boots on the Ground says LO needs to start selling her horses. She has to. Stargazer Kawaii says, did you see the accusation towards the judge? Look at me, daddy. He. What? Oh, no, I didn't see that. I did not see him saying that. Exit Sign says, what this all tells me is I'm way too slow at life to be a lawyer. No, that's not what it's telling you. So Sabine Simone says David Greengrass really regged up the bill. I think they all did. They had to do a lot of discovery on this case. They did a lot of depositions on this case, a lot of moving parts. So I'm not hating on the fact that he had multiple lawyers. I'm just hating on the fact that I be having to do it by myself. Okay. Maybe my boss will hire more attorneys so they can help me out. No, it's okay. I like doing the work. Okay, and I have a problem. My problem is I need to actually see stuff. I don't even assign things to my paralegals to be like, hey, review this and tell me what it says, because I need to read like every single word. Y'all see me do it on the live stream. Kimmy will highlight and say this is important and this is not important. I will still read it because I'm nosy. Like I will still read it because I'm nosy and I want to know what it says. And I want to draw my own conclusions because people can interpret things differently. So I wouldn't do well working on a team of multiple lawyers, to tell you the truth. Jason Swabby says she means par for the course. Oh, makes sense. I'm not a golfer. Why would y'all think I knew that? Par for the course, it's a golf reference. It means it's totally something she would do. Makes sense. Thank you for explaining that to me, and hopefully I don't forget it. Kimmy Locker says Laura making accusations against Whitnick was par for the course. Makes sense. Thank y'all. Thank y'all for teaching me something new, as always. Fair for all says Gringus said it. Gringus said, Gingis. I can't say that. I got a lisp, y'all. Part of my mouth is numb. Okay. Fair for all says, Gringus said it's pronounced Jing gas. Jing plus gas. Jingle bell gas. Jingas. Jingas. That's not cool. Okay. I know sometimes I say people have cool names, but Jingas. Jingas. I feel like I'm cussing still. Jingas. Jingas. I don't like it. I don't like it at all. Jingas. Jing. I guess it's not horrible to say. I guess it's not hard. I'm already calling them green grass. Jingas. No, see? I'm not good. I'm not good at similar what do you call it? Similar sounds. Like whatever. Let me move on. I'm not a speech teacher, y'all. Zoe V says every billable hour was worth it to stop Laura from continuing to exploit men. Plus Greengrass, people are putting it in there. Really just changed this man's whole name. Plus Greengrass caused more work with his extra show motions that were all denied prior to trial, like he's doing with his change of judge. Maybe same tactic still after trial. Coach Karen says girl could buy her some Cabbage Patch Kids, and even that is kind of scary. The American Girl dolls, like why don't she just get one of those? Or they had like Baby Alives. Do they still make Baby Alives? They should have those little creepy robots. She can have one of those little creepy robot things. She can have a freaking Baby Alive. It's alive. It's a baby. She could have made it look like Clayton. And then when the child gets older, she just gets an American Girl doll. Come on. Think smarter, Laura. Think smarter, not harder. This is hard to convince a man to love you when you could just buy a doll, $30. It's easy. 100. Those things be like $100. A says, Bree, your stream quality is always so high. Thank you. Thank you very much. Is it? I'm like, I need to decorate. Just look plain. It looks like I'm in jail a little bit. Thank you. Cheryl Reed says, lovely and expensive. Very, very expensive team. Exit Sign says, people are saying 50% for appeal, but I don't know. 50%, do you mean like 50% that they'll succeed on appeal? Amanda M says, originally, I think he hired them for the injunction. I already forgot. To stop the harassment. I forgot what the A stands for. Dang it. Island says Whitnick had clearly had a client accused. Whitnick had already had a client accused by Laura. Yes, I remember that. Oh, I thought you meant that Clayton had 2 cases with him before. Beth Insermi, I hope I'm saying that right, says courteous to Clayton because Whitnick had a score to settle. Okay. Courtesy to Clayton because when they had a score to settle with Clayton to make it per se. So not it wouldn't be per se, but I can't think of any other words. They weren't charging him. That's the goddamn word. It's not pro se. It's something else. Pro bono. That's what it is. It's pro bono if they weren't charging him. And he knew it would be good for publicity for the firm. Yeah, he's going to get a lot of clients now if they're paying attention to this kind of stuff. Island says they didn't rep Clayton before they rep previous victims. I got it now. I was confused. Y'all know I'd be confused. Avid Reader Red XX says Clayton Echard also had a protective order case and injunction harassment. Injunction against harassment. That's what it is. Case with her. Yes, I do recall that. Cheryl Reed says that call went nowhere. She would never settle. She believes her own lies. Oh my gosh. If I was not dealing with someone, a couple of people like that right now in my own cases, I'd be like, bruh, just stop talking. Does anything you're saying make sense to you? In their head, yes, it does make sense to them. But it's just like, for people that are sane, it's very hard to sit there and listen to the nonsense that some of the people say. And they really believe it. That's the part that beginning. You really believe that, don't you? Just Me MD says, did you guys already state what the total was? Yes, Kimmy pulled it for us, $154,242.76. Only charges related to the trial and the things that the court awarded was appropriate. There were other charges for other things that the court said they were not awarding attorney's fees for, which was the injunction against harassment and the order of protection hearings. Okay, we got Stargazer Kawaii says, yes, the look at me daddy is real. No way that's in that document. No way. Widget 81 says, you need to look at the look at me daddy. I'm a real judge now. Line and Green gets motion for change of judge for cause. It's wild. No way. Coach Garrett says, well, I imagine all the investigation time tracking down her false records in Timu Tummy. Not in Timu Tummy. Crystal Yo's member of the channel saying, I don't work well as a team at all. Yeah, me, I'm too nosy. Island says, Gene Grass. Jingrash. But see, and then I start lisping like green grass, green Jingrash, green Gingrass. I don't like it. It's still not a cool name. Not cool. Okay. Cheryl Reed says, I like green grass better. Me too. It's easier to say. Maybe because grass is green. Coach Karen says, get your green grass on. Yeah, get your green grass on. I cannot. Exit sign says the AI generated song pronounced Gingrass closer to how he says his own name. Before the court date, we were all using a hard G. Yeah, because it's better. It's better. Definitely better. Equality says injunction against harassment. I'm going to keep forgetting. I'm sorry, y'all. I'm trying to do better, but so many words coming out of my mouth and through my eyes. It's a lot. Okay. We got Fair for All. Send it a $9.99 super chat. Thank you very much. We appreciate it. She doesn't want a baby. She wants a man. Ding, 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 ding. I wish I had one of those. I don't think Deacon Fatal was here, so that should have been okay. Sorry, y'all. Shout out to Fair for All. Absolutely right. She doesn't want a baby. She wants a man. Hence the contracts to get the man. Thank you for the super chat again. I definitely appreciate it. Just Me MD says she should have to pay every penny of that. It's high as hell. Add another billable line for wasting everybody's dang time dealing with this foolishness. Extra sanctions for my girl, for sure. Zoe B, thank you for the $19.99 super chat. Shout out to y'all tonight with the super chat. Definitely appreciate it. Says, thank you for sharing your expertise and for always being super positive. Your laugh is contagious in the best way. Thank you very much. I'm feeling really annoying. But I definitely appreciate it. Definitely appreciate the super chat as well. Thanks for supporting the channel. We got Coach Karen says, I think in cursive some days to bring. Yeah. I feel like that's me. I don't know. My words just leave as soon as I get on live stream and I start speaking like a preschooler. green grass. Okay. Boots on the ground says, just call him Dingus. I'll probably mess that up too. Y'all, I have like for those of that don't know, that are kind of new to the channel, and I can't even talk right now, I have like a numb part of my face, so it's hard for me to say certain words. And then also my brain, I think, thinks faster than I speak. That's why I stutter a lot. In my opinion, that's why I stutter a lot. So there's just some words I'm never going to pronounce correctly. And then once I figure out a comfortable way to say it, it's just going to stay that way. Sorry. I'm sorry. If anyone can't stand it, that's just what it is over here on the BriHive. Bri doesn't know how to talk. But she gets on the internet and says she's a lawyer. If you are a real lawyer, the fake internet lawyers attacking Laura Owens. Okay, y'all. We are at 99 likes with 80 people watching live. Our like goal for the stream is 100. So we only have 9 more likes to go until we hit our like goal. We are an hour into the stream. Don't know how we got here, but we are here an hour into the stream. Let's go ahead and hit the like button if you haven't already. And then we can do our little like goal thing. Kimmy went ahead and found us the starting point for, what is his name? Clayton's expert's testimony. Stop, be quiet. I don't know if y'all can hear that, but I could hear it. To see if she ever actually said that it was closed. And now I feel like y'all are going to be right. And she never actually said it was closed. So let's go ahead and check it out. Boom. We're going to make it big. Thank you, Kimmy, again for finding this for us. We're going to have Bossy B bring us into it. And then we're going to get into Laura Owen's motion to change the judge. Okay, so Bossy B. Okay, let's go ahead and stop sharing this screen and then share this screen, and then we'll be on our way. Boom. Here we are. Let's check it out. Y'all let me know. Let me redo it because I don't remember if I actually pressed. Okay, no, I did it. Okay. Get it together, Bri. Okay, so let's see her testimony. Let's see if she actually ever says that Planned Parenthood is closed. I'm gonna put it on 1.5. Y'all let me know if it's too fast or too slow or whatever. Let's go.
Lightning fast. Introduce yourself to the court, please.
Hi, I'm Dr. Samantha Deans.
Where'd you go to medical?
It's not loaded.
School.
Indiana University School of Medicine.
Are you board certified?
Double board certified.
What's your first board?
Obstetrics and gynecology.
And your second board?
Complex family planning.
Well, you have 2 fellowships?
Just 1 fellowship.
Thank you. Do you teach?
I do.
Medical students and physicians?
Medical students and resident doctors, yes.
You teach them gynecological and early family planning?
Yes, complex family planning.
All right, thank you, Professor Deans. You've provided us with your CV, which is Exhibit 39. I'd move to admit. No objection.
B39 received.
You also did a report for us. It's Exhibit 41, which we'll pull up on the screen. Did you have an opportunity to review the medical records for Laura Owens?
Yes, the ones I was provided with.
Exhibit number 41. Did you know that was published online on a website?
Just to confirm, I'm looking at my report, and no, I did not know that was published on.
Y'all, so I played this. I played this thinking that we were just gonna get to the point. But I also forgot about all the other ridiculous things she had to testify to. So I'm actually happy that we're rewatching this because Laura doesn't seem like this, or doesn't seem to think that she was a good expert, but this is already top tier testimony in my opinion.
Did you give Ms. Owens permission to publish your report on a website?
I did not.
Okay. Judge, I'm tendering Dr. Deans as an expert here. No, I have one voir dire question for her.
Sure, go ahead.
Dr. Deans, hi, good morning. How many children have you delivered as an OBGYN?
Probably too many to count, but I would say at least 3,000 at this point.
Okay, I stipulate to her expertise.
So stipulated.
All right. Basic question, Dr. Deans. I'm going to go fast here. Do you have concerns regarding the legitimacy of some of the records you reviewed?
I do.
If this court were to assume that the June 1st HCG test actually came from Laura, would that confirm pregnancy?
No.
What is the medical standard of care to confirm a pregnancy?
That would have to be either serial HCGs showing a trend over time, or a pregnancy test and or an ultrasound, or a physical exam that confirms an injury during pregnancy.
And we had none of that here, correct?
Correct.
All right, I'm showing you exhibit number 28. Are you aware that that sound from Laura? Are you aware that that was altered?
Yes, I am.
Laura claimed it was anonymous and from Planned Parenthood. Any thoughts about that?
Patients cannot be seen anonymously at Planned Parenthood. Planned Parenthood, having been a former medical director of Planned Parenthood, PPFA, which is our national guidelines, require identification at the time of a visit to confirm the identity of the patient. The patient can't be seen anonymously.
Thank you. Laura claimed she was pregnant with twins. Anything you reviewed in any of the medical records confirmed that Laura was pregnant with twins?
No.
Laura claimed that the twins were boy and girl gender. Anything that you reviewed that confirms that?
No.
Do you recall reviewing the October 16th HCG test? I think it had a 100 or 3-digit HCG level on it.
I do.
Are you aware that there's actually 2 other versions of that exact same test in circulation?
I've heard that. I have not seen them.
If I told you there was another version with 1,000 times higher HCG level, would that cause you concern?
Yes, it would.
Are there alternate causations for a positive HCG test as we have here?
Yes, there
Did you review the, well, I'm going to skip over the photos. Did you review Dr. Medshill's report?
are. I did.
You're aware that Laura first claimed she miscarried in September, October, and then the photos.
I think that's all the testimony we're really going to get about Planned Parenthood. I think that's what I confused it with, that she used to be a former director and she couldn't go anonymously. Do y'all want to continue to watch it to see if she ever talks about what were we listening for again? To see if she ever talks about whether Planned Parenthood is closed on Sundays. Let me know if y'all want to continue to hear it. I am going to check the pretrial briefs though, because I feel like it had to be somewhere other than just in the judgment in our chat. It had to be somewhere else in the actual record, not just on the internet sleuthing, right? So I don't know how much longer she goes. She goes a little bit longer. Let's see. She probably goes for like another 5 minutes. So I think we can watch it. I think we can watch it. Let's finish it out and see. And now,
report indicate that it happened in the 3rd week of July, correct?
Correct.
Pursuant to Dr. Medshill's report, he concluded, do you agree with his conclusion that the data here warrants that Laura was 99% pregnant?
No, I do not agree with that assessment.
Do you agree with Dr. Medshill that the record confirms, this is from his report, a May 20th conception date?
Absolutely not. There's no data to confirm a conception date at this point that would require an ultrasound dating of a pregnancy.
Professor Deans, thank you. Judge, I just moved to admit exhibit 41 if I didn't already.
Any objection?
No objection.
41 proceed. Cross-examination when you're ready.
Dr. Deans, you reviewed records that showed that Laura had HCG in her blood October 16th, 2023. You familiar with those?
Yes.
Where did that HCG come from?
It could come from a variety of sources.
Okay, and your report mentioned some of those sources. I'm just going to ask about specific things. Exogenous injection, I'm assuming that's a fancy way of saying sticking yourself with a needle.
Correct. Exogenous would be an HCG source from outside of the body.
And do you have any information? Have you seen any records that suggest that that happened here?
I don't.
Okay. Heterophilic antibodies, which I did a little reading on that. Some sort of allergic response, it sounds like maybe.
Correct. An autoimmune response can be triggered by exposure to animals and create positive tests.
Okay. But the fact that Laura tested negative for pregnancy November 14th would appear to be inconsistent with at least the heterophilic antibody theory. Would you agree with that?
It depends on the type of test. A urine pregnancy test might be positive, but a blood test could still be positive. It depends on the assessment and the level of HCG at the time of the test.
Okay. And I think Dr. Medshill said, and I think you also said that cancer can cause elevated HCG levels. That's a fact, right?
Correct.
And have you seen any records to suggest that Laura has cancer presently or that she did in 2023?
Not presently. No, I know there's a discussion of a prior history of ovarian cancer.
I understand that. But regarding 2023, if Laura had cancer in 2023 that caused false positive pregnancy tests between May and October, when the last one was, how can you explain her testing negative in November?
I think it makes that less likely unless she had treatment in the meantime.
And another option that you wrote about in your report was something called familial HCG syndrome as being a way that someone could test positive, have HCG in their blood, not from pregnancy, correct?
Correct.
Do you know how rare that is?
Very rare.
I read that it was about 10 cases on the planet. Does that sound about right to you? And again, if Laura had familial HCG syndrome, that would explain some false positive tests in the middle of the year, but it wouldn't explain the negative at the end, would it?
That is correct.
Dr. Deans, in your report, you talked about objective evidence of pregnancy. On the first page in particular, you said that the only objective evidence of pregnancy is a Banner urgent care serum quantitative HCG from, well, I think that's actually a misstatement. The October 16th wasn't at Banner, but there was a serum HCG, and you've referred to that as objective evidence of pregnancy. Is that true?
Correct.
And in the absence of some other explanation, cancer, familial, horse tranquilizers, or whatever, in the absence of some other explanation, you would agree, and Dr. Medshill, I think, said that HCG test from October 16th is objective evidence of pregnancy, right?
It is objective evidence, and one of the possibilities of that objective evidence is pregnancy.
Right. And if a woman is pregnant, regardless of how much or how little prenatal care she has, she's still pregnant, right?
If they are pregnant, yes.
I mean, a woman could be pregnant and have no ultrasound until the day the baby comes out, and she's still pregnant, right?
I am pregnant.
Yes, and the objective data would be the baby coming out of her body.
Right. And Dr. Deans, you worked, or your report and your resume indicated that you worked at Planned Parenthood for a while.
That's correct.
In that capacity, did you counsel women regarding terminating their pregnancies?
Correct.
And just for the record, I'm strongly pro-choice, strongly Planned Parenthood. If a woman was choosing or was thinking about choosing to terminate her pregnancy, why would she have prenatal care?
Oftentimes patients seek care first to confirm their pregnancy before they make their decision about how to end it.
But in a lot of states,
Wait a minute. That doesn't even make any sense. She wasn't planning on terminating it. She's planning on trapping a man. So what? You're trying to put in facts that are not in evidence. She did not say she was planning on terminating it. So
I'm sorry to cut you off, but we're out of time.
I'm out of time. Thank you very much. Thank you.
No redirect. Thank you, Professor Deans. We appreciate your help.
All right, any
Thank you.
objection to the professor disconnecting?
No.
All right, thank you.
okay. So yeah, she didn't say it. I thought she did. Don't know where we got that from. Really don't know where we got that from, but let me go ahead and see what the chat has to say about it. I do remember her testifying about Planned Parenthood, and that's where I think I confused it. Let me know where y'all think y'all confused it. And let's have Bossy B bring us in back to the chat. Girl, where you at? All righty, let's see what we got. We got Star saying, I love you. You are fun. Thank you very much. I am a complete joke, but I appreciate it. Island says the Planned Parenthood was closed from Megan. The Planned Parenthood was closed from Megan Fox. She called them and tried to schedule an ultrasound. Why? Just look online. Star says the judge is allowed to confirm new testimony. We got Zoe B saying like goal achieved. Awesome BriHive dropping the queen being all the membership emojis. And let's go ahead and check for ourselves. Did we hit our like? Oh yes, we are at 110 likes. Shout out to the BriHive. Okay, shout out to the BriHive. For those of you who are new here, you know that, or you don't know, we have a light go animation where the boom in the beginning is really, really loud, or in my opinion, it's really loud. If you are sensitive to sound, this is your time to turn down your volume so that we can play our like goal animation, and it's going to play in 3, 2, 1. Again, shout out to the BriHive. Definitely appreciate it. Okay, and then we got a response to the request to file. Jeez, I just read it. What is it? Clayton responded to Laura's request to change judge already. So Kimmy just put it for us. We're going to be like the first ones in here. We're first ones in here. I don't know if we are. Someone else probably already covered it. But here we are. Thank you, Kimmy, for grabbing that. And I forgot. Let me see who gave it to us. Okay, Island, thank you so much for grabbing that for us. We're going to check it out after we actually get through Laura's actual motion. We got Cheryl Reed saying, yay, we hit the like goal. Thank you for that. Widget 81 says, it may be in the full version of her report. I have not reviewed the actual report. Star says, even if there was a new trial, she would have to defend her prior testimony, and then they will let the evidence in of it being closed. Of it being closed on the weekend, then that evidence will come in. Let's give us another shot, okay? And again, I don't think that they would turn the whole case over on that. That's not something that the court really relied on. She didn't provide any evidence that she was actually pregnant. Doesn't really matter whether the place that she claimed to have gone was open or closed, because she already admitted that she doctored the evidence. So what does it matter whether they were open or closed on Sundays? Okay? Star says where she committed perjury, she wants this to continue. That is crazy. That is her new defense. Exactly. You're mad because she may have looked up common fact, which would be available to the public, like going on Google and finding out what time Planned Parenthoods are open, right? Which the judge may be able to do. I'm pretty sure she can do that. She is allowed to research. You're going to rely on that when you lied the entire trial, including, and this will always be the biggest including to me in this case, including changing the location of the actual Planned Parenthood you went to? Okay. Or did Laura testify to it? Did Laura testify to it? Because didn't Deandra not ask? That's a bad question. Didn't Deandra ask her, how did you go on July 2nd and it was Sunday? Or am I making that up because I want this to be true? And then she said, no, it's not in Los Angeles. Or no, I think she said you didn't look for the records in Los Angeles. I think that's what it was. Okay, I'm trying to make up testimony. Get me off the bench, y'all. Get me off. Island says she did tell Clayton Echard she would terminate if he dated her. Yeah, but she wasn't there yet. She wasn't planning on terminating yet. Okay, it was not. All right, let's go ahead and jump into her actual motion. So, oh, excuse me. So we can get a move on this. Let me close the attorney's fees thing, and then we'll go ahead and share my screen, girl. Okay, I changed my settings back here, so it's not doing what I want it to do. Anyways, Bossy B, bring us in. Okay, y'all. Let's look. This is the notice of change of judge for cause, memorandum of affidavits and support. We are not going to go over all of the facts of the case. Oh, I'm not showing it to y'all. We are not going to go over all of the facts of the case because this document is already really long and we're already an hour and a half into the live stream, and I did not plan on streaming for 4 hours tonight, but it sounds like we are going to. I can't. No, I might. We streamed till 11 o'clock before. It's okay. No, I shouldn't. Anyways, let's go on. We're not going to read all the facts of the case because we are all pretty familiar with what happened in this case. And if you're not, we have plenty of videos already on the channel talking about the case. And there's plenty of our colleagues on YouTube talking about this case as well. So Kimmy did me a favor and highlighted all of the important things. So we are going to read the things that Kimmy has deemed important, and we're going to trust her. And I'm not going to be nosy this time. So this is Laura Owen's motion to change the judge because she does not like Judge Mata. Okay. As explained below, there is clear and convincing evidence demonstrating the judge currently assigned to this matter, Honorable Julie Ann Mata, is biased, prejudiced, and has engaged in conduct which violates both Laura's rights to due process of law under both the United States and Arizona Constitution, and which separately violated Rules 2.9a and 2.9c of the Arizona Rules of Judicial Conduct by inter alia, performing an independent investigation into the facts of the case, considering and relying upon information posted on the internet about the case, and engaging in ex parte communication regarding the case with her father. Now, let me go ahead and say this. Off jump, sir, where is the evidence? You know what? Kimmy attached some evidence for me in the drive. I haven't looked at it yet. This sounds like speculation to me. This absolutely sounds like speculation to me that you're assuming that that's what she did. But I digress. Let's go on. This conduct, while sufficient to warrant additional other relief, including but not limited to a new trial, please don't do a new trial, man, establishes grounds to disqualify Judge Mata on the basis of bias and prejudice within the meaning of ARS 124095. For these reasons, Laura respectfully requests that Family Court Presiding Judge Honorable Rhonda Fisk review this matter and to find that grounds exist to disqualify Judge Mata and to promptly reassign this matter to a new judge. Okay. So they're just asking to change the judge. This is not the appeal. So you're just asking to change the judge to decide the attorney's fees issue? That's weird. Okay. If that's what you want to do. In the event Judge Mata disputes the allegations set forth below, Laura requests the Family Court Presiding Judge set this matter for an evidentiary hearing pursuant to Family Law 6.1d2, and that upon doing so, the court approve the issuance of subpoenas ad testificatum to Judge Mata and her father. Y'all want her daddy to testify? Okay, they go ahead and go through the facts. He was on The Bachelor. She hooked up with him. Laura claims that she had a one-night sexual encounter with Clayton in Scottsdale on May 20, 2023, and she learned she was pregnant 11 days later. She claims she tested positive for a pregnancy 5 different occasions. We are going to skip over everything going on. They started the case as pro se. They went ahead on December 4th, 2023, court administration issued a notice placing this matter on inactive calendar and scheduling the matter for dismissal on February 2nd of 2024. Shortly before the case was due to be dismissed for inactivity, Clayton retained counsel Greg Woodnick, who appeared in the matter for the first time on December 12, 2023. Mr. Woodnick immediately filed several pleadings, including a motion to amend Clayton's answer on the petition or to the petition filed on December 12, 2023, and a motion for Rule 26 sanctions filed on January 2nd, 2023. Notably, Mr. Woodnick filed these pleadings without making any attempt to meet and confer with Laura as required by Family Law Rule 9C, and he moved for Rule 26 sanctions without ever providing written notice to Laura of her right to amend or withdraw her petition as required by Family Law Rule 26C2B. Shortly thereafter, Laura retained counsel Alexis Linval, who appeared on December 22nd, 2023. Y'all doing all this before Christmas? Okay. And filed a motion to dismiss with prejudice on December 28, 2023. Days later, Ms. Linval withdrew from this matter with Laura consent on January 2nd, 2024, because she probably knew you was lying. Confusingly, on June 25th, 2023, or 2024, Judge Mata issued an order granting Laura's motion to dismiss. In that ruling, the court indicated petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Judge Mata then set an evidentiary hearing on those issues for June 10th, 2023. The undersigned was first retained to represent Laura on March 25th, 2024, after appearing in this case. Undersigned counsel quickly discovered that Mr. Woodnick filed a Rule 26 motion for sanctions, among other pleadings, without first consulting with Laura or her counsel, and the sanctions motion was filed without giving the mandatory 10-day written warning required by providing written notice to Laura of her right to withdraw her petition, as required by Family Law Rule 26. After counsel discussed the problems and despite initially refusing to do so, on April 3rd, 2024, Mr. Woodnick filed a motion to withdraw his Rule 26 motion for sanctions. Unfortunately, the request was not timely ruled on by the court, resulting in the undersigned filing a motion for judgment on the pleadings as to the issues of sanctions on May 10th of 2024. On May 29th of 2029, we are now 5 years ahead, guys. Typos. You were talking about Judge Mata's typos, and you're all the way in 2029 while we're all still in 2024. Okay. On May 29th, a minute entry order was issued explaining the court had intended to grant Clayton's request to withdraw his motion for sanctions, but due to a clerical error, the acceptance was not remitted to the parties. Despite the motion for sanctions being withdrawn, and despite no other sanctions or fee motions pending, the case proceeded to trial. On June 17, 2024, Judge Mata issued an order finding in favor of Clayton as to substantially all issues in the case and awarding attorney's fees in an amount to be determined by later application. The post-trial order also purported to find Laura lied about being pregnant in this case, as well as two other matters, and that she may have committed perjury in this case or elsewhere. The order is not entirely clear. Based on those findings, Judge Mata referred this matter to Maricopa County Attorney's Office. Since receiving the post-trial decision, Laura has discovered evidence of extremely serious misconduct by Judge Mata, which is more than sufficient to remove her from this case for cause. Laura will also seek by separate motion a new trial and a complete reversal of all prior rulings issued in this case by Judge Mata due to her misconduct in addition to other relief. And so what I would assume here is that they're not asking for the new trial and to overrule all her rulings until they get a ruling over whether she's going to basically be recused, taken off of the case. Same thing that Glanville is facing over in the Young Thug trial. So essentially, it sounds like they're going to wait on a ruling to see if the court agrees with her that she should be removed from the case, and then they'll file the motion for a new trial. Okay, let's talk about the legal standards a little bit. Before we jump into the rest of the argument. The legal standard under Rule 6.1 provides grounds A party seeking a change of judge for cause must establish grounds by affidavit as required by the rule. For other reasons, the rule permits disqualification of a judge by showing the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. So they're basically saying that Judge Mata is being unfair. Now, they go on to say that there is no express time limits in this rule, but the courts have basically determined that there is a time limit, and it is that this must be done before a trial actually starts, which was what we talked about on my pre-recorded video, where the rule states that you have 30 days or 60 days before the trial actually starts. For whatever reason, he signed into a case rather than the actual rule that tells him that he needs to do it before the trial actually starts. But he goes on to say that there is another rule. Which one did we cover, Kimmy? Was it 6.6 or I think it was just rule 6. So this is rule 6.1. Only requires that a party seek a change of judge for cause within 20 days after discovering the basis for the request. Thank you, Greengrass. I was asking you to get me the additional rule you were referring to because Rule 6 did not say any of this. So anyways, let's go on. Rule 6 only requires that a party seek a change of judge for a cause within 20 days after discovering the basis for the request, and the rule expressly provides case events or actions taken before that discovery do not waive a party's right of change of judge for cause. I'm gonna have to pull up that Rule 6 again because I don't think you could just erase Rule 6 because you found out something later. But either way it goes. This broader rule, which permits a change of judge after trial, makes sense given that family law cases are unlike civil matters, often continuing in nature. Because the family court judge may hold multiple trials and or evidentiary hearings in the same case over a span of many years, it would make no sense to interpret Rule 6.1 as depriving a party of their right to disqualify a judge for cause simply because the judge held one or more earlier hearings before the grounds. I think that makes sense. Rather, the text of the rule merely requires a party to raise an issue promptly, even if that occurs after trial or hearing. That does make sense. So I'm not going to hate on Greengrass for that. So the rule that we covered, I believe, was just Rule 6. This is 6.1, basically saying if they determine that the judge is, biased or that they should be removed for cause rather than kind of like the preemptory, I don't want this judge, I think they're going to be biased. But after determining that they are biased, then you can file a motion within 20 days. And that's basically what he's doing. As explained in the concurrently filed affidavit of counsel, the grounds upon which a change of judge are requested in this case are primarily based on misconduct committed by Judge Mata, which shows in her post-trial ruling on June 18, 2024. They basically use facts not in evidence. Although this single issue is sufficient to grant relief requested, there is also evidence showing other misconduct committed by Judge Mata, including the fact that she engaged in improper ex parte discussion of the facts on this case with her father. How? I would like to know how. We'll get through it. Although Laura and the other side counsel heard rumors about Mr. Blank appearing at the trial on June 10th, the specific details of exactly what occurred and proof to establish these facts was not fully known until undersigned counsel returned from his pre-planned vacation on June 28, 2024. Did y'all talk to her dad? I don't think you did. Anyways, they filed it timely within 20 days after his vacation. He needs to continue to tell us about this vacation that he continued to talk to us on instead of enjoying his freaking vacation with his family. He filed this after he came back, right? So, clear and convincing evidence shows Judge Mata's conducting an improper ex parte investigation into the facts. The details of the grounds for disqualifications are set forth in the affidavit counsel submitted herewith. Let's see. Where was I at? To summarize those grounds, these requests is primarily based on the fact that there is clear and irrefutable evidence that Judge Mata conducted an ex parte investigation into the facts of the case, and even worse, at least one of her post-trial factual findings on a critical important issue was based solely on information posted on the internet and not in evidence. And that's literally when Planned Parenthood is open. Let me see. Is his affidavit attached to this one or is it in a different document? I just want to skip to the affidavit because I don't really care about none of that. Okay, this is where the green is. Okay, so this is David Greengrass. Do we even agree with him, or do we even care what he says is true and what's not true? We've read his blog, okay? So he's David Greengrass. He practices law. And let me stop before he turns like Jeanette Braun and get mad at people and say we're bullying him for calling him the wrong name. Okay, he has been an attorney since 2004 in Arizona and 2002 in California. I'm glad he left California. I don't want to have to practice with him. They go on to do a case summary, as we just read not too long ago. Okay. Are they actually citing? No, they're not citing the actual transcript. He's just reciting this. He was retained by Laura. This is a summary of the media and public attention. Despite being an otherwise simple and short-lived paternity matter, this case quickly gained local, national, and even international media attention and massive public scrutiny. There appear to be two main reasons for this. First, Clayton is arguably famous as a result of his recent appearance on a nationally televised reality TV dating program called The Bachelor. This media attention is relevant and important to understanding the basis for this notice because it appears the trial judge, Julie Mata, allowed the significant media hype and public attention to overwhelm her better judgment. Speculation, eventually causing her to engage in conduct which violated Laura's right to due process, including her right to have this matter heard by a fair and impartial jurist. Because that issue is key to understanding what happened here on the grounds for disqualification raised by Laura, this subject is discussed in some detail. For anyone who is not familiar with the show Bachelor, we're not going to read that. He basically dated a bunch of women to see who he likes. Clayton appeared as the star of season 26 of The Bachelor, which aired on ABC from January 3rd to March 15, 2022. As a result of his appearance on the popular show watched by millions of viewers, Clayton gained some degree of nationwide fame, and his role on the show was heavily promoted and advertised by ABC, as it is true for all seasons of the show. Clayton is just, a lover boy on the TV show. This leads to the second aspect of the case, which caused it to gain far more media and public attention than normal. Yeah, she wanted this one to stay under wraps because the other one stayed under wraps and this one got too big for her britches, right? She could not handle it. She couldn't control it. She couldn't make him date her. That's my opinion. Okay. Let's see the next part, which caused it to gain more media and public attention than normal. As the previous star of the nationally televised TV show like The Bachelor, Clayton has a large and highly devoted fan base, including many followers on social media. For example, Clayton currently has nearly 300,000 followers on Instagram and more than 60,000 on TikTok. Hater. These facts, Clayton's fame, and the huge popularity of The Bachelor, coupled with the extreme odd allegations in the case, the Laura faked being pregnant with Clayton, have caused this otherwise simple case to gain a massive amount of public scrutiny and attention from the local, national, and international news. What does this have to do with the judge violating the rules? Yes, we know it is a famous case, okay? We get that. What does that have to do? Where's the proof that she conducted in wrongdoing? Where is this? We don't care how famous Clayton is. It's basically she did this because Clayton is famous on Instagram. Okay? That's basically what you're trying to convince the judge. Get to the point. Get to the misconduct. Get to it. Okay, here we go. In addition to being widely covered by traditional news outlets, it was not widely covered by traditional news outlets. This case has also received massive attention on social media, including sites like Reddit. Now, that's where the national attention came from. Reddit, Twitter, and YouTube, among others. For instance, any anonymous fans of Clayton have created social media pages focused entirely on this case, including a Twitter account using the hubristic sobriquet Justice for Clayton, or JFC. The JFC Twitter account has posted obsessively about this case nearly 3,500 times, one example of which is shown below. Wishing a happy and safe 4th of July to everyone but Laura Owens and David Green. Was this year? Oh my gosh, when was this posted? This was this year? It was this year. It only freaking views. Come on, stop being so sensitive. That's not nationwide. It has freaking 57 likes. Come on, I can post a TikTok right now and get 57 likes. Dude, and I haven't posted in TikTok in months. Well, a couple weeks ago and the months before that. But come on. 57 likes, bro. 2,000 views is what you're crying about. National recognized. They keep posting about us and no one's watching. It looks like freaking Laura Owen's blog likes. No, she got like 7 likes on there. Okay. In addition to posts on Twitter, anonymous fans of Clayton have created websites devoted solely to this case and to promoting their belief that Clayton is somehow a victim who deserves justice. One such pro-Clayton fan site is justiceforclayton.com, which contains copies of all or substantially all pleadings in the case. This site also contains a one-sided narrative which highlights only those facts favorable to Clayton's version of events while carefully avoiding any discussion of facts unfavorable to Clayton's narrative. Greengrass. Have you not read your blog, Greengrass? Have you not read that thing? Because I did. It only took me one time to see the one-sidedness of it. Have you not read Laura's blog? Yeah, usually when people are writing about things and they have a bias, they tend to write biasly about it. Kind of like you do on your blog. Yeah, that thing. And Laura's blog too. This seems like another blog. Like, you should have just wrote this on your blog instead of filing a motion. He should have left this on the internet. He should have never filed it with the court. Never filed it with the court. Come on, bro. The Justice for Clayton website is so biased against Laura. Get off the website. Get off the website. Just because we go to your blog and talk crap about your writing, don't mean you have to go to Justice for Clayton blog and go talk crap about their writing. You're a hater. You are a hater. You gotta go back on that boat and get more vacation because you should not be hating this hard, okay? In addition to social media posts from his fans, Clayton himself has been extremely personally active and publicly promoted this case, giving countless media interviews in which he tells his side of the story, as he can. Why would he tell her side of the story when it's a lie? Let's talk about that. How about that? Does Laura get on the internet and tell Clayton's side of the story? No! Like, what the hell? Oh my gosh. This is so hypocritical. This is the most hypocritical motion I've ever read. You are literally doing what you're claiming that Clayton does and that these blogs do. And you're blaming Clayton for people writing on blogs like he has any control of that because they can see how ridiculous this case is. Let me get off my rant. We got too much to cover, okay? Stress is all I have to say. Let's go on. Where are we at? Clayton himself has been extremely personally active in publicly promoting this case, giving countless media interviews in which he tells his side of the story. You mean like how Laura took her side of the story to The Sun, okay, and other blogs? Clayton's attorney, Mr. Whitnick, has also published statements regarding this case, including a press release issued on, at least it's a press release and not a blog, in which Mr. Whitnick accused Laura of fraud, suggesting she had been accused of fabricating pregnancies and doctoring medical evidence as a means to extort relationships several times, dating back 10 years, because she did, in an attempt to respond to some of the one-sided narrative, acting at Laura's request and with her written permission. I have occasionally posted comments about the case online. Blah, blah, blah. You have nothing else to do. That's my opinion. Primarily on my personal website. Yes, get off the internet, Greengrass. Get off the freaking internet. You're talking about these people that are on blogs. You're an attorney. Why are you telling your case online while the case is still ongoing? I don't care if you have permission from her. Like, you sound ridiculous. This is pissing me off. Why? Tell me this, BriHive. Why, when I read the freaking motion for attorney fees, I had no emotion. It was not that entertaining. And then when I get into Greengrass's motion, it's ridiculous. Like, what the hell are you talking about? What does this have to do with her misconduct? You're basically rewriting the story that benefits you. People like Clayton too much. And so we should get a new judge because people like Clayton. That's my argument. That is my argument, and you should listen to me. People should stop liking Clayton. Give me a new trial so we can make people not like Clayton. What kind of argument is that? I even wrote about it on my blog, and people still didn't believe me. Okay. Yeah, we still don't believe you, Greengrass. And on my Twitter account, get off Twitter. How old are you? Get off Twitter. Oh my gosh. Focus on your case next time. Maybe if you focus on your case, you wouldn't have run out of time. You would have been able to finish the freaking case instead of tweeting and writing blog posts. Guess you didn't have enough money to write too many more motions. That's why you started writing blog posts. Come on now. The purpose of these comments has been, no, these are not comments. These are whole articles, blogs. I said I was going to stop yelling, but I'm not. Okay. The purpose of these comments have been primarily, if not exclusively, to respond to information being circulated about the case by Clayton, his lawyers, and or his fan supporters. Why? Why do you need to do that? Prove your case in court, which you didn't. You didn't do that, and now here you are. Oh, wow. Dave Neal and Megan Fox got a whole section in this thing. Still nothing about what the judge did. Still nothing. When I post comments on either Twitter or my personal website, members of the public can and often do post responses /comments/replies. This point is important for reasons I will describe below. YouTubers Dave Neal and Megan Fox. Whole section for our buddies on YouTube. Before discussing the specific issues and conduct given rise to Laura's request to disqualify Judge Mata, it is important to understand some of the other participants who will be mentioned further below. Why are you mentioning them? They're not in the case. Two such participants are individuals named Dave Neal and Megan Fox. I do not personally know. Yeah, so shut up. I do not personally know either Dave Neal or Megan Fox, but during the course of this proceeding, I have become generally familiar with them. You have obsessed over them, in my opinion. According to his YouTube channel, linking my guy's whole YouTube channel, Dave Neal, I hope your channel grows because of this. Dave Neal is a stand-up comedian who lives in Tennessee. Okay. Dave also creates and publishes video on YouTube nearly every day. Dave's videos often focus on The Bachelor and people like Clayton who have appeared on that show. Over the last several months, Dave Neal has obsessively published hundreds of hours of videos regarding this case, again, often on a daily basis, as reflected on his YouTube channel below. These videos are generally almost universally devoted to viciously attacking Laura and often me, Greengrass. Okay, and you're attacking him in a court document. Get off his YouTube channel. You don't have to watch it, but you're gonna put it in a whole court document, bro. Get the hell. Okay. These videos are generally almost universally devoted to viciously attacking Laura and often me. You're a grown man. Get over it. Let's see. And proclaiming Clayton is a victim and who deserves justice. Notably, Clayton has personally appeared in several of Dave Neal's videos, and it is clear that Dave Neal is not covering this case as a neutral journalist, but rather a passionate, obsessive advocate for Clayton. He can do that, though. He can do that if he went to his freaking YouTube channel. What does that have to do with what the judge is doing? Shout out to Dave Neal. Another YouTube following this case is an individual using the name Megan Fox, who I believe is a resident of New York State. I do not personally know Miss Fox. I believe that name to be a pseudonym, but she has contacted me via email several times during this case, and I understand that she claims to be a journalist who publishes stories on an extreme far right-wing news website. Like Dave Neal, Megan Fox also creates and publishes videos on her YouTube channel here. Like Dave Neal, Megan Fox is a passionate supporter of the JFC cause, and her videos are overwhelmingly devoted to exposing and destroying Laura, while promoting the narrative that Clayton is an innocent victim who deserves justice, which he was granted during the case. But I mean, I guess he missed that part. Dave Neal and Megan Fox are mentioned because they are relevant to the issues raised herein. This is so because they attended the trial held in this matter on June 10, 2024. And after the trial, both appeared on video claiming to have or speaking with others who claim to have direct knowledge regarding certain improper conduct committed by Judge Mata during the trial, including the fact that Judge Mata allegedly engaged in improper ex parte discussions about this case with her father, who also personally attended the trial and socialized with members of the JFC group, because he can. There's nothing stopping her dad from anything. Nothing. He can talk to who he wants. Those points are explained further below. So again, you're talking about Dave Neal and Megan Fox said that they heard and they know these things, but you don't know them personally. And have you spoken to them personally? I would assume not. But maybe I missed some things on the internet over the last few weeks. But you're saying you heard this on their channel? Is this not like outside research that you're accusing the judge of to help your case? Guy, let's come on. Shortly after I became involved in this case in late March 2024, several events occurred which initially caused concern regarding Judge Mata's possible bias and lack of neutrality. Specifically, immediately after Laura retained me to represent her in this matter, I attempted to obtain a copy of her file from the previous counsel. Unfortunately, Laura's prior counsel did not promptly respond to this request. This made it impossible for me to respond to a motion to compel filed by Clayton before I was retained. The response to the motion to compel was due mere days after I was retained. That's not no one's fault but yours. Because I could not respond to the motion to compel without a complete copy of Laura's file, and because Mr. Woodnick refused to agree to an extension of time on April 1, 2024, I filed a lengthy and well-supported motion seeking an extension of time to respond to the motion to compel. The motion explained that the request was primarily based on the fact that I did not have a complete copy of Laura's file because her previous counsel did not promptly provide me with you took on the file. You took on the case though. That's no one's fault but yours. Despite the fact good cause existed for my request for an extension, and despite the fact that Mr. Woodnick did not oppose the motion, just days later on April 3rd, 2024, Judge Mata issued a one-sentence minute order filed April 5th, 2024, denying my extension request without any explanation. She doesn't have to grant that, though. She doesn't have to grant that. You took on a case that you knew an answer was due to, and you didn't respond. The court does not have to wait for the opposing counsel to get you the information. Again, stop crying, dude. Stop crying. Okay. Of course, I am also well aware that as a matter of law, adverse judicial rulings alone do not support a finding of bias or impartiality without a showing of an extrajudicial source of bias or a deep-seated favoritism. Yes, exactly. For that reason, I determined that although Judge Mata's unexplained and apparently baseless denial of my extensions, it wasn't baseless. She doesn't have to grant that extension request. Raised concerns about possible bias, and the adverse ruling standing alone could not support a finding of bias. As such, I took no action at the time. Shortly thereafter, I discovered that in the motion to compel, Clayton's counsel, Mr. Woodnick, made multiple statements to the court which appeared to be knowingly false. After I confronted Mr. Woodnick with these concerns, he refused to speak to me by telephone for several weeks. Given the fact I was newly retained and not familiar with the complicated history of this case, Mr. Woodnick's refusal to speak with me made it much more difficult to prepare for the matter for trial. So you're crying because you wasn't prepared for trial and you lost? That's what I'm getting from this. For that reason, on April 8, 2024, I filed a motion entitled Motion to Compel Lunch and for Alternative Relief. In that motion, I informed the court that Mr. Woodnick has disputed. Mr. Woodnick, are you tattling? Mr. Woodnick was refusing to speak to me by phone despite multiple rules of procedure and professional conduct which required counsel to meet and confer by phone. As a result, I asked the court to order Mr. Woodnick to speak to me in addition to other alternative relief. To support that request, my motion cited an earlier ruling from Honorable Pendleton Gaines, which said in which Judge Penny Gaines granted a virtually identical request, noting the court has rarely seen a motion with more merit. The motion to compel lunch will be granted. But on what basis? They don't have this. You didn't give us any fact from that case. What are you talking about? Unfortunately, as she did with my request for an extension of time to respond to motion to compel on April 30th, 2024, Judge Mata issued a single sentence minute order denying my motion to compel lunch. The order denied my request without any analysis or explanation. You want too much. You want too much. You want too much. Later that day, on April 30, 2024, I learned for the first time that Clayton's counsel intended to use previously undisclosed evidence and witnesses at trial. Due to the untimely and extremely late disclosure within an hour of this discovery, I filed an emergency motion bringing the issue to the court's attention, and I requested an immediate scheduling conference to discuss the issue further. Despite the fact Rule 76.1 provides the court must order a scheduling conference when requested, on May 22nd, 2024, Judge Mata issued a minute order denying my request for a scheduling conference, again without any explanation or analysis. Have you ever thought that maybe your motions are harassing? Have you ever thought about that? Have you ever thought that maybe you came into the case late and you kind of prejudiced yourself because of that? No, you didn't think about that? Figure it out. Figure it out. Taken together, Judge Mata's single sentence, zero explanation denial of these three motions, the request for an extension of time to respond to the motion to compel, the request for the order requiring Mr. Woodnick to speak to me. Do you know how ridiculous that sounds? You know how ridiculous that sounds? There are other ways to meet and confer. And maybe those rules did say that were written in 1901, maybe. But there's other ways to meet and confer. You're just saying he refused to speak to you by phone. That doesn't mean he refused to speak with you through email, by text message, by jogging in the street after work. You're saying he refused to speak to you by phone. Grow up. And the request for a scheduling conference caused me to have serious concerns regarding Judge Mata's bias and lack of neutrality. Or maybe your documents just weren't drafted that well, or maybe they weren't under the right laws. We know you like to cite the wrong things, so there's that. However, I continue to believe that despite the existence of what appeared to be apparent bias and hostility, Judge Mata's adverse rulings alone would not support a finding of bias. Exactly. They're just adverse rulings. Sufficient to seek her disqualification. Because of the rule, a party challenging a judge's impartiality must overcome the presumption that the judges are free of bias and prejudice, and the corollary standard that adverse rulings alone do not support a finding of bias or impartiality without a showing of an extrajudicial source of bias or a deep-seated favoritism. Okay, let's see. Summary of judicial misconduct and bias at trial. Let's go. We're finally getting to the point. This matter proceeded to a bench trial before Judge Mata on June 10, 2024. Prior to trial, I learned that Dave Neal, and Megan Fox, among other JFC supporters, were planning to attend the trial to support Clayton, or to be nosy. I watched it to be nosy, so there's that. It is my personal belief that the courts are publicly funded fora. Trials and legal proceedings belong to the public and should always remain open to the public. I further believe, as a matter of law, that members of the public have a near absolute right to observe and report on events which take place in court. So what's the issue? So I viewed the public interest in attending and observing the trial as a good thing. No, you didn't. Overall, when I arrived at court on the morning of trial, I was surprised to see dozens, if not hundreds of people waiting to watch the trial. Before trial began, Judge Mata spoke to counsel in her chambers and informed us that she had created an overflow room for at least 50 observers to watch the trial, and the seating in the courtroom itself was packed with spectators. Judge Mata informed counsel that she had taken certain security precautions due to the large crowd of spectators. I found Judge Mata's comments about the crowd surprising because prior to the morning of trial, there was nothing filed in this matter aside from a small number of media requests for filming. That would suggest such a large crowd was likely to attend. Based on this, it appeared Judge Mata gained some personal knowledge. Come on, bro. Seriously. If media is requesting to come to the trial and people have been showing up to other hearings, why would she not prepare for this to be a big hearing? Doesn't mean she did research. She could have just heard, hey, a lot of people are covering this trial. You think there's going to be a lot of people at the trial? And maybe she thought, let me just be safe. Because maybe she would have done that and only 2 people came to the trial. That does not let you know that she did anything wrong. Okay? So based on this, it appeared Judge Mata gained some personal knowledge regarding the large crowd size and was not obtained from nor shared with the parties or counsel. Again, she could have just been prepared. It could have been 3 people there and they didn't need the overflow. I don't think that's a good argument. Let's go on. Shortly before trial began, I became aware that Mr. Woodnick intended to call witness named Mike Maracchini. Mr. Maracchini is an ex-boyfriend of Laura's. The pair dated for approximately 2 years while living in San Francisco in 2017 through 16 through 17. During the relationship, Laura claimed Mr. Maracchini violently assaulted, causing her traumatic brain injury that eventually resulted in Laura developing epilepsy. Based on this abuse, Laura sought and obtained a domestic violence restraining order from San Francisco County Superior Court, a copy of which is attached here too as Exhibit A. Ooh, we got the restraining order. That order, later renewed, remains valid and in effect as of today. Ooh, I'm going to read the restraining order. On June 9th, 2024, Clayton posted a video on his Instagram page standing next to Maracchini. He appears on the right as shown here in the video and elsewhere. Clayton suggested Mr. Maracchini intended to appear at the trial in this matter despite the DVRO issued against him. Great. She looks to have a type. At least there's that. On the morning of June 10, 2024, Laura informed me that she saw Mr. Maracchini in the courthouse with Clayton and Mr. Woodnick. Based on this, Laura told me she was too terrified to participate in the trial. She was also terrified when JFC laughed and snickered in the crowd. So, I'm not that convinced by her terrifiedness, okay? I probably need to get to some chats here. Based on this, Laura told me she was too terrified to participate in trial, and she told me she intended to leave unless the DVRO was enforced. Bye. There would have been a ruling against you, sis. Having no other available option, I immediately contacted court security and asked them to enforce the California court order by removing Mr. Maracchini from the facility. Superior Court security officers informed me they did not believe that they had authority to enforce the order, and they suggested the only option was to call 911 and ask Phoenix PD to enforce the order. Based on that suggestion, I called 911. Oh, you're giving us an excuse now. Explained the situation and asked the officers to enforce the order. After a few minutes, the Phoenix police responded. They reviewed the California court order and explained to them that pursuant to federal law, the Violence Against Women's Act, they were required to enforce the California court's order as written. I provided the officers with a copy of the specific provisions and the Violence Against Women's Act, which made interstate enforcement of the order mandatory, and I directed their attention to the specific language of the order shown here that required the order to be enforced in all 50 states. The court jurisdiction over the parties and subject matter of the restrained party has been upheld for the notice properly. This order is valid and entitled to enforcement in each state. If this shall be enforced if it were an order of that jurisdiction. So what this means, Greengrass, she would have had to register the order in Arizona. If it's not registered in Arizona, Arizona police do not have any jurisdiction. Okay? It says right there where you have it underlined, shall be enforced as if it were an order of that jurisdiction. Oh no, I read it wrong. Never mind. But either way, it still needs to be registered in the state because it's not going to pop up. You can show it to them. You're supposed to register it. I read it wrong, but you're supposed to register it. Let's go on. As I also explained that by traveling from California to Arizona for the purpose of violating the order, Mr. Maracchini committed a federal crime pursuant to blank. He didn't do it. I'm going to have to see this restraining order. I'm going to have to see the restraining order because generally it gives you an exception for in court. Okay, let's go. As I also explained that by traveling, we already got that. Despite this, Phoenix police indicated they believed they had no choice but to defer to Judge Mata on the issue. As a result, immediately prior to the start of trial, I asked Judge Mata on the record to enforce the California court order by removing Mr. Maricini from the courtroom. As she had done with substantially every other request, Judge Mata denied my request without any explanation. As a result, Laura was forced to sit in a court just feet away from Mr. Maricini, which caused her nearly to become overwhelmed with fear, panic, and anxiety. You mean like how she sits right at the same table as him during a domestic violence restraining order renewal hearing, just like she did at whatever trial she went to? Come on, girl. You're doing too much. At the conclusion of the trial, I informed Judge Mata on the record that I was leaving the country later the evening for a family vacation in Europe to celebrate my mother's 80th birthday. I was about to say something mean. I'm going to move on. I left Arizona the evening of June 10th, and I remained in Europe until I returned home on June 28th. The majority of this time was spent on a cruise ship in the Mediterranean with my family, and during that time, my internet access was extremely limited. The ship's Wi-Fi connection was so slow that I was unable to view videos posted on any medium, including Twitter and YouTube during the cruise. While I was on vacation, Laura contacted me and told me about some extremely disturbing info. You had cell phone connection, but not Wi-Fi or not internet access? Okay. All right. Laura contacted me and told me extremely disturbing information being shared on social media by Dave Neal and Megan Fox. Specifically, Mr. Neal and Mr. Fox appeared on several live streams and other videos in which they claimed Judge Mata's father was present in the overflow room during the trial, and they claimed Mr. Blank spoke with several of Clayton's supporters during and after the trial, proclaiming, "I'm here for the S show." So what? Another individual claimed Judge Mata's father sat with them and expressed that he was here for the circus. So what? Laura assembled excerpts of some of these videos, which are available for viewing here. Why can't I click it? Why can't I click it? A CD containing these videos is also lodged herewith. As unusual as this may be, the mere fact that Judge Mata fathers attended the trial, if true, is not primary concern. Okay, what's your primary concern? The concern is that according to the comments from Dave Neal, Megan Fox, and others appearing on the video with them, Mr. Blank stated Judge Mata discussed the facts of the case with him prior to trial. By saying what? One such specific statement was made by a person named Blank, who speaks between 0 and 40 seconds in the above video compilation. Sorry, y'all. I'm getting tired. In her remarks, Ms. Blank claims that she spoke with the judge fathers at or immediately after the trial. Ms. Blank stated that Mr. Blank was carrying papers with him, which based on her comments may have been Laura's request of findings of fact and conclusions of law. What? Miss Blank further claims Mr. Blank told her Judge Mata showed her father Laura's request of told Judge Mata showed her father Laura's request for finding of fact and conclusions of law, and she, Judge Mata, told him, Julie told me just, Dad, you have got to read this and print out a copy for him. Are you going to bring these people to testify? You're submitting hearsay. Oh, gosh. In the course of making these remarks, Ms. Blank, you haven't even talked to this woman. You haven't even talked to her. And you're using this as support for your motion. Oh, please, judge reviewing this. Please, please, please. It's hearsay. It's hearsay. In the course of making these remarks, Ms. Blank also made statements which appear to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. The discussion of that point is brief and not entirely clear exactly, I can only imagine, but my belief is based on Ms. Blank's claim that Mr. Blank whipped out papers that Julie printed them for him. Then she mentions Laura's request for finding of fact and conclusions of law, finally asking, did anyone see those were denied prior to trial? What is also extremely disturbing is that in the video compilation, upon hearing remarks regarding Judge Mata and her father, Dave Neal laughingly commented, to paraphrase, hold on, we don't need a mistrial. That specific comment from Mr. Neal appears between 40 seconds and 1 minute in the above video compilation. I understood those remarks from Dave Neal as a signal to the person speaking that they should not disclose further information regarding the comments they claim to have received from Judge Mata's father, because the person is given hearsay, and people like Mr. whatever your name is, Greengrass, and Laura Owens are always on the internet watching Dave Neal's video and can interpret things however they want to interpret them, and then try to spin it and then file a motion for a new judge. That's probably what it meant. Just like when I say in my opinion, so that you people watching these YouTube streams thinking everyone's just obsessed with you, don't try to sue them for defamation, because this is our opinion. Okay? So again, you're basing it off of people that are not in the legal field saying, oh, we can't get a mistrial. How do you even know David Neal's understanding of what a mistrial is? You don't. So let's go on. I understood those remarks from Dave Neal as a signal to the person speaking that they should not disclose further information regarding comments they claim to have. They claim, yes, to have received from Mata's father because her believed, who wrote that? Because her believed they would expose judicial misconduct and bias on Judge Mata's part, requiring a new trial if those facts are exposed. Again, you're still talking about hearsay. I don't see how you think you're going to prove anything with this. Assuming Judge Mata did, in fact, share information about this case with her father, that conduct would appear to be a pro se violation of 2.9a of the Arizona Code of Judicial Conduct. Despite allegations, my personal view based on the past several months is that Clayton followers are generally not honest and reliable. You just said you're relying on their statements, but you also think they lie. And I consider the possibility that the claims regarding Mr. Mata's father may be fabricated, either in whole or in part. How do we know you didn't hire these people to pose as JFC people to say these things? How do we know that? How do we know that? We don't even know if you are in charge of these people that went and spoke to Dave Neal. These could be anybody. They could have never even spoken to the father. So you're going to go ahead and say all of these things based on hearsay of people you haven't even talked to, and you don't even know their intentions behind saying these things. Come on, bro. You got to be smarter than that. Okay, thank you, Kimmy, for the restraining order. He got to be smarter than that. Okay, so you know they could be fake. Given how serious the issues are, I did not believe I could ethically make a formal accusation of judicial impropriety without taking some reasonable steps to verify the truth of what happened. Okay, let's see what you did. In an effort to ascertain the truth, while on vacation on the morning of June 17th, before I received the post-trial decision, I sent an email to Judge Mata's division in which I raised concerns regarding Judge Mata's father and the alleged statements made by Dave Neal and Megan Fox. In this email, while noting the highly unusual circumstance, I asked Judge Mata to promptly provide a response to the allegations regarding her father. She doesn't know, she wasn't there. We already talked about this on a previous recording, y'all. I further explained that if these allegations were true, I believe they may support a change of judge for cause. A few hours later, I received an email response from Judge Mata's division. To the extent that either party wishes to bring a matter to the court's attention, the court respectfully asks you to file an appropriate motion, which is an appropriate response. Yeah, that's an appropriate response. A true and correct copy of the email is attached. About 14 hours later, on the morning of June 18th, 2024, I received the trial's post-trial ruling on the merits, a copy of which is attached here too. You had Wi-Fi then? And you had Wi-Fi to send the email. Okay. I think you also had Wi-Fi to watch the videos too. After reviewing the June 18, 2024 decision, which found in favor of Clayton as to virtually all issues, Laura and I immediately noticed something truly shocking. The ruling contained findings that were not based on any evidence at trial. Instead, those findings were clearly copied from posts on social media. Specifically, to cite just one obvious example, on page 10, Judge Mata made certain findings that were purported based on the trial testimony of Clayton's medical expert, Samantha Deans, is OBGYN who previously worked for Planned Parenthood on the East Coast. As shown below, Judge Mata made a specific factual finding that according to the trial testimony of Dr. Deans, Planned Parenthood is not open on Sundays. which petitioner testified she sought care on July 2nd, 2023. I got to go back and look at Laura's testimony because I feel like she testified that she went and I feel like Saturday came in somehow, but I'll have to go back and watch it. Without belaboring the details of the entire history of the case, the question of whether Planned Parenthood was or was not open on Sundays was relevant and extremely important. We all know that she doctored the sonogram. So again, I don't think that's a hill to die on, but sure, let's go on. It was irrelevant. This is because the trial, Laura testified she sought a care from Planned Parenthood in Southern California on July 2nd, 2023. As it happens on July 2nd, 2023 is a Sunday. Therefore, if Planned Parenthood was not open on Sunday on July 23rd, absent some explanation, that would appear to disprove Laura's claim she sought care on that day. Okay, let me tell you something. Greengrass. You know what disproved that she sought care on that day? That she doctored the sonogram. That's what did it. That she admitted to doctoring the sonogram. And then she turned around and told us throughout this case that she went and mission mission Viejo. And then during trial, during cross, told us actually it was in Los Angeles. That's what disproved that she actually sought care on that day. I don't know if you forgot about that part, but that's really relevant here. Okay? Let's go on. But here's the problem. Dr. Deans never testified about this issue at trial or at any other time. To prove that point, attached here too is Exhibit E, a true and complete copy of the court transcript from her testimony. As the transcript clearly shows, at no time during the brief testimony did Dr. Deans or anyone else ever address the question of whether Planned Parenthood was or was not open on Sundays. That question was never asked, nor was it answered. If Dr. Deans did not testify that Planned Parenthood is not open on Sundays, where did Judge Mata's finding on the issue come from? The answer is again, absolutely shocking. Judge Mata copied the finding from a post on social media. She couldn't have looked at Planned Parenthood website. She couldn't have done that research. Okay. As noted above, during the course of my involvement in this matter, I have published a small number of comments. That's not a comment, sir. It's not a comment. It consists of several comments because it's a whole freaking blog post. 15 posts you've made during this case. Regarding the case on his personal website, this is a tiny, insignificant fraction of the commentary published by Clayton and his followers. As noted above, the JFC Twitter account has posted nearly 3,500 tweets about the case, and the number of other posts on the social media, certainly in the tens of hundreds of thousands, if not millions. Let me see how long I got on his rambling. I'm gonna lose my place. Okay, almost done. Okay. As limited as my online oh my gosh, dude. As limited as my online involvement in this case has been, I believe Judge Mata conducted her own independent research into the facts of this case, and that this involved her reviewing comments posted on my website or other social media. Because the judge wanted to see your stupid website while you talk trash about her. The belief is based on the following facts. First, again, belief, assumptions. Oh my gosh. You have no evidence. First, throughout this case and repeatedly at trial, Clayton's counsel, Greg Woodnick, ferociously. I've never seen that word spelled out. Because that's not what it says. Vociferously. That's not even a word I just said. Okay. Complained that Judge Mata about the fact that I was making public statements about the case via my website and Twitter, and Mr. Woodnick specifically provided copies of articles I wrote and posted on blank about this case. I found Mr. Woodnick's complaint in this regard confusing because the information and comments I posted about the case were not improper in any way, and because Clayton and his supporters, including Mr. Woodnick, had also posted public comments online about the case, suggesting that Mr. Woodnick fully understood I had the right to inform the public of Laura's side of the story. Based on what I know now, I believe that by pointing to the comments on my website, Mr. Woodnick was not actually concerned about the contents of those posts. Instead, I believe he was suggesting or hinting to Judge Mata that she should go online and perform an ex parte review of my site. And I believe that this is exactly what she did. The belief is based on the fact that immediately after Laura finished testifying at trial, literally later the same day, anonymous supporters of Clayton began posting comments on my website and also on social media, asserting Laura committed perjury when she claimed to have sought care from Planned Parenthood on July 2nd, 2023, because that day was a Sunday and the Planned Parenthood isn't even open on Sundays. But that came out before the trial, if I recall correctly. This specific comment was posted by an anonymous user on my website on June 10th, 2024. So you're going to have to prove that this lady went on your website. You realize that, right? A week before Judge Mata posted her trial decision. I'm pretty sure that came up prior to trial ending. And how do you know that Judge Mata doesn't have her own experience with Planned Parenthood? Maybe she was there trying to go on a Sunday. Have you ever thought of that? She can use her own experience, right? Yeah, she can. They go ahead and post the comments on Gringa's website. The evidence supports two conclusions. First, Judge Mata. No, it doesn't. No, it doesn't. I already know what you're about to say. It doesn't. The evidence supports two conclusions. First, Judge Mata's finding that Planned Parenthood is not open on Sunday did not come from the trial testimony of Dr. Deans, nor did it come from any other witness. Indeed, the word Sunday does not appear anywhere in the transcript. With that much is beyond dispute. Second, the evidence shows Judge Mata violated Rule 2.9c of Arizona Code of Judicial Conduct by performing a secret, undisclosed investigation into the facts of the matter. But you're assuming that it's the facts of the matter. Planned Parenthood is public information. Whether they're open or not is public information, not facts. She gave us the fact that she went on July 2nd. Are you saying that she shouldn't be able to look at a calendar and determine what date July 2nd was on? Come on, bro. Is that also research, Greengrass? What's going on? Resulted in seeing comments from Clayton. Let me see. Second, the evidence shows that Judge Mata violated the rule by performing a secret, undisclosed investigation in the facts of the matter, which clearly would have resulted in her seeing comments from Clayton supporters regarding their beliefs as to Planned Parenthood's operation. Can we all Google Planned Parenthood and see if it's open on Sundays? Can we Google that? Let me Google it right now. God dang it. Bro, Planned Parenthood. Let me see about my Planned Parenthoods in my neighborhood. Planned Parenthood. Let's look at. She could have only seen it on your blog, Greengrass. You think that many people are going to your blog? The only way we can determine whether Planned Parenthood is open is if we go to Greengrass's blog. Did y'all not know that? Let me see if his website pops up anywhere on here. Oh, wow. Would you look at that? I don't see anything about Greengrass. I'm on Google and those Google businesses pop up. And then my freaking phone shows me that they're closed on Saturdays and Sundays. How do you know she wasn't trying to go there? How do you know she didn't try to take her sister there? How do you know? How do you know? I know she probably messed up. There was plenty of typos in that ruling. I will give you that. There is plenty of typos in that ruling. I also know, sorry, y'all, I got to stretch my legs. I've been sitting for like 2 hours straight. I also know that listening to a bunch of testimony during a trial is hard. It's hard. And then putting it together in a judgment. She remembers the fact from somewhere, and she put that it came from the testimony of the expert. Could have been a mistake. Is it a mistake to get her off of the case? I don't think so. Y'all let me know what y'all think. You think this is the reason to get her off the case? I don't think so. Okay. The only way she could have found out about whether Planned Parenthood was open is if she went to good old Gringus law firm website. Okay? So next time y'all need to know when Planned Parenthood is open or closed, make sure you check out Gringus's website. Because that's the only place the judge could have found that from. Laura gave her the fact of the date. Google probably gave her the fact of the freaking date it was open. Or maybe her own experience. Because judges can draw from their own experience. How do you know she didn't try to go there multiple Saturdays last year? Or Sundays last year? You don't. Dumb. Let me not be mean. Sorry. You're not a dumb. Okay. The fact that Judge Mata based her post-trial ruling on anything other than admitted trial evidence demonstrates beyond a preponderance of evidence that grounds exist to disqualify the judge from her matter on the basis of bias and prejudice. The same is true of Judge Mata's decision to have ex parte discussions about the case with her father. That's not an ex parte discussion. He's not a party to the case. What are you talking about? People are allowed to talk about cases. She can't give who she's talking about, but she can talk about it. The legal arguments supporting those conclusions are set forth in the memorandum of law filed concurrently pursuant with the Family Law Rule 6.1. For the reasons stated above, I can't even read anymore. For the reasons stated above, I have grounds to believe, I do believe that on account of bias, prejudice, and other interests, the judge currently assigned to this matter, Honorable Julie A. Mata, is unable to act fairly and impartially and is unable to provide petitioner Laura Owens with a fair trial, including a fair retrial, which Ms. Owens is currently requesting. Blah, 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 declare under penalty of perjury. Judges are able to draw from their own experiences. It is not, let me see. I didn't know that Greengrass's website was like where you find out if Planned Parenthood is open or not. But he should really promote that because it didn't pop up first on my Google search. So I don't have time to go through the actual rules that he cited, but I am going to take a peek at some point. Y'all know I'm getting mad. Okay, and Kimmy is reminding me about the daddy part of the affidavit. So let me scroll up. Y'all, I'm so sleepy. We're going to read Clayton's and then we're going to go to bed. I might not get to all the comments. Okay. Page 12 of the document or 12? Okay, it's all the same. So Kimmy told me to check it out and says, last paragraph, right? Okay. This shameful conduct not only violated Laura's right, it raises serious questions regarding Judge Mata's fairness as a judge of the Superior Court. Any reasonable objective observer in Laura's position would be justified in wondering, was my case fairly decided based on the evidence, or was Judge Mata simply trying to express her father? Look at me, daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. He. Dude, I'm sorry. I didn't even show it to y'all. What? Was Judge Mata simply trying to impress her father? Look at me, daddy. I'm a real judge now. Watch me destroy a young woman's life because the other party was on The Bachelor. He. What is she, Michael Jackson? Like, why is she saying he? This guy, one thing I would give him if he ever gets disbarred, because one thing I would give him if he ever gets disbarred, become a creative writer, Green Gas. I think that is your calling. A creative writer, absolutely your calling. Lawyering, you might be running out of time there. I know you're not that old of an attorney, but you might be running up on your time on lawyering. But creative writing, I think you'll do fabulous. I think you would do really good in creative writing. Really good. And that's a compliment. That's not me being mean, okay? Let's go ahead and have Bossy B bring us in. Y'all, I'm to the point where my lips is getting ashy. My lips is getting ashy. Okay, what I wanted to do too was pull up this goddamn restraining order and see if it looks like the restraining orders that I'm used to reading. It is. It definitely is. Let me download it. Oh, wait, let me see. Where is it normally? Okay, let's see. I can't remember where the exception is, so let me. Sorry, y'all. I'm just trying to find the section where you can go to court. Let me see if I can download it and do it that way. Let me see if I can search the document. Sorry, y'all. I'm researching while on the stream because I don't remember exactly where, because this is a permanent restraining order and I usually deal with temporaries. Did I not just download this? Where'd it go? Download. Okay. Why is it saying these are the exhibits? Oh, because that's what it's called, huh? Okay, control find. Okay, it searches it. Court. Too many things. I'm trying to find where it says this does not apply. Okay, here, it might be stay away. I don't remember where it is. Maybe I'm wrong. There should be an exception for there should be an exception for when you are in court for this not to apply. But I can't remember where it is. And it looks like the parties actually agreed to the restraining order rather than the judge finding that she was abused, from what I could read. Okay, maybe I'm wrong. I'm pretty sure there's an exception for court hearings, but I can't find it on here, and I'm not all the way familiar with this form. Okay, let's see this one. Sorry, y'all. I'm just staring at the screen, probably looking crazy. Okay. Or maybe this one doesn't have it because it's a permanent restraining order. So never mind. In the temporaries or the temporaries, you can be around the person for court. And maybe I'm not looking for the right language and I don't have time to read it all. So we're just going to go with maybe there is no exceptions for when they are in a court hearing, but usually there are because there's like bailiffs there and stuff. So anyways, let me go ahead and jump into the chat. I may not get to all the chats that can be started because your girl is tired. We're almost 3 hours in on the live stream and I'm probably going to get in trouble when I get off this live stream messing with YouTube. So let's go. Kimmy, can you drop the link to the response in the... Oh, no, I have the drive right here, huh? No, I don't. Yeah, if you can drop a response to her answer or to her request in our back channel, that would be great if you can. Okay, we got Hope Johnson saying Gillespie and Whitnick drug and kidnap in SA. Yes, that's what she accused them of. Widget 81 says, also not sure if you knew County Attorney Rachel Mitchell did confirm that an investigator has been assigned to look into perjury charges. This was after the letter writing campaign had started. No, I did not know that. Widget 81 says, but it's a felony charge, so they have 7 years to file. Hopefully they file it soon, so she'll stop. At least lock her up for a little bit so she won't do it anymore. Amanda M says Laura Owens would really like a male judge. She thinks men are easier to manipulate. Women just see through her. She wants to try her fake crying again. Chelsea B says it's wild to me that her lawyer, bound to the rules of ethics, is continuing with this clown show and wrote this motion. I agree. I would like to see how he proves that this misconduct. I would love to see it. He watched the video on YouTube, but he's getting mad because Mata may have looked at his website, which I doubt. I doubt that would be her basis for information because it's filled with lies. Okay. Kimmy Lockett says, I think it's pretty telling that Gringas only mentioned one attorney before him. I think it's pretty telling that he only mentioned one thing of misconduct, allegedly, that he could probably prove. He's not going to be able to prove that she talked to her dad about this case. Highly doubt it. Coach Karen says she is pissed because he turned it over for criminal action to be reviewed. So now she's trying to save her butt, right? No privilege, all public information. Laura Owens is publicly putting her own out there. Yeah. Shara Hellville says, nah, disagree. She kept threatening him to go public. I think she was relying on the idea of believe women and no one questioning her. Exactly. He kind of, retaliated against her. Or not retaliated, but he got his justice. She should have left him alone. Widget 80, she picked the wrong one. Widget 81 says she couldn't handle the attention, but she is the one that went to the media first and she couldn't put the cat back in the bag. Yep. Exactly. Exit Sign says she went to the media in the first place. Yeah, if she didn't do it, this would not be an issue. Stargazer Kawaii says all Laura's facts have been proven to be fake. Exactly. And she's trying to find anything, grasping at straws. Kimmy Locker says better go back to that boat. Laughing my hell. I was like, I did tell him to go he needs to go back on that boat. He's still a little woozy. He needs to go back. I forgot I said that. Alex P says Gringas and Laura are hypothetical birds of a feather that flock together. Kimmy Luckers says writing a blog is not the same thing as posting a comment, my guy. It's really not. It's really not. What are you talking about? I made a couple of comments. Sir, you wrote a whole novel. Okay? You did not post a comment. Exit Sign says, oh, like when they have proof you're accusing a judge based on hearsay. Not hearsay, double hearsay. They're proving it on double hearsay. It's multiple people saying that her daddy said this. Daddy's not even there to tell you what he said, and he's not going to tell you. Even if he did say it, I bet you will never find out. Never find out. Okay, what are you going to do? Forensic examination on her freaking computer? Destined to Be says trying his case in court of public opinion. Yes, he did, and he's sucking. And there's Tanya D, a member and moderator of the channel. Welcome in. Sarah Hellville says he's a whining Karen. Right, he's like trying to rewrite the script. I hate when people do that. Tanya D says, y'all know Spicy Brie is my favorite. Thank you. It was coming out. Amanda M says this is just publicity for his Twitter account, right? He's trying to grow his followers to freaking Clayton status, right? Cheryl Reed says this should be rejected as false filing. Yes, all the false information in there. You're trying to manipulate the judge. And again, like I'm still a little bit confused about what he's saying she did wrong. All I got was you claiming her daddy said something. No proof of that. And you're claiming that she looked at your website. Of all things, you would have been better off saying that she Googled something because you just talked about how she got overturned because she Googled something a couple of months ago. And I don't even think that was accurate because judges are allowed to research. I'm just so annoyed. Coach Karen says, is this supposed to be his letter to mommy because daddy said no? What the F forecast is going on here with green grass? Exactly. He is tattletelling. She didn't rule in my favor. Mommy said I couldn't play with the toy. Can this new judge let me play with the toy? No, Greengrass, go home. Kimmy Lockett says Greengrass sure uses the word obsessively a lot for someone who's represented a person who fakes pregnancies to get dudes and is obsessive about it. Don't forget that. Alex P says, I can't believe he's trying to control what the general public think and say about the case online. Exactly. And then he's complaining about it while he's doing the same thing. I need to get her story out there. You get it out enough in court and it's bad, okay? Zoe B says Greengrass is high on his own ego. He talks a lot of trash in form of court filings, blog posts, and tweets, desperate for attention just like his client. And the thing is, he knows we're going to cover it. So he thinks he's getting his narrative out there, but we're just making fun of him. Yeah, we are. Island says Greengrass also threatened Dave Neal that he was going to take his house while Dave's wife was 6 months or 9 months pregnant. Oh my gosh. Get a life. Does he not have a life of his own? Does he not have a wife of his own? A kid of his own? That's too much going on. Floral Funk, I like that name, says Greengrass can lose his license, right? Yes. Star says Dave Neal was doing fine before Low and can you learn how to breed all of them? I'm so sleepy, y'all. Star says Dave Neal was doing fine before Laura Owens. In fact, he was an innocent, nice man. This case has been hard on him emotionally. And then like you're attacking his character and you're getting mad because he's making YouTube videos. Stop watching them. Like, come on, we're all adults. Island says that's her real name. Whose real name? Amanda M says she's an actual journalist, so that's her name. Oh, for Megan Fox, I don't think that's her real name. What do you think? She's trying to be the actress Megan Fox? Stargazer Kawaii says Megan Fox is her real name. She is not far right, and the newspaper she works for isn't far right. Even if she was, that wouldn't change the facts of the case. Yes, what does that have to do with anything? There was no reason for him to mention that, even if it was true. I for sure agree with that. Exit Science says, bizarre that this guy is acting like this big intellectual, but he can't seem to fact check himself or correct his typos because he's in 2029. Maybe that's what it is. We're just all late. Like, we're behind. They're in the future and we're like in the past. I think that's what's going on. Widget 81 says, you took the case as you find it. You took the case as you find it. Exactly. If you're going to sign up for something where there's a response to a motion to compel yeah, that's a problem. I found out about that recently on one of my cases, and I'm like, you didn't tell me that there was a motion to compel pending. I don't know if I can do that, right? Exit Sign says, yeah, because he knows your 2 hours of whining is going to cost the client $1,000. Yeah, true. And then you're making Clayton pay more by responding to this dumb motion. Cheryl Reed says he's as silly as his client. Motion to compel lunch. And then getting mad that the judge said no, he does not have to eat lunch with you, fool. He is not going to lunch with you. Stargazer Kawaii says Woodnick was responding to email and wanted everything on record. The evidence was his client's information. Exactly. We got to get everything in writing with you, Greengrass, because you be lying. You be lying and you be posting blogs and lying. Okay? Amanda M says, I think they came to see the trial after months of reading your dumb filing, Greengrass, and the court was just being prepared. Doesn't mean she talked to anybody. Doesn't mean she's been watching the videos. Doesn't mean any of that. She's probably watching them now. It's very entertaining. Exit Science says, jealous. Nobody brought him scones. Amanda M says, pretty sure Woodnick knew that there would be a lot of people there, and they probably notified the courthouse and or the judge staff. They seem to know there would be some amount of people there. Or maybe someone on the staff for the court said, hey, there's a lot of attention on this. I think we should, be extra prepared, and pass that to the judge's attention. It could have been a clerk. It could have been a bailiff. Maybe the bailiff likes watching this case. There's nothing stopping the bailiff from watching the case. So you sound dumb. Like they could have just been talking to Greengrass. You sound dumb because they could have just been being prepared by information that they received from inside the court. Okay? Exit Sign says everyone at the courthouse knew who these people were when they walked in. Yep. Stargazer Kawaii says 100, maybe hundreds. No, it was definitely not hundreds, right? They're trying to act like it was the Cardi B trial or the Johnny Depp trial. Island says people who were there said it was 50 to 60 people. I wish I took a head count because Greengrass just lies. Okay. Kimmy Lockett says, so Gringas heard through the grapevine supporters would be there, saw dozens, not hundreds when he arrived, but the judge taking security precautions response is surprising. Okay. And also you're complaining about, Maricini being there. Aren't you happy they took extra precautions? They can put him in the spill out room. Amanda M says Gringas knew he was going to be at the trial long before anything on IG at the courthouse. He threatened to have him arrested way before the day of trial. Yes, he's a liar, pants on fire, just like his client. Alex P says Laura also claimed in her lawsuit against Uber that a car crash caused her epilepsy. At this point, the YouTube video is about to cause that girl epilepsy. Star says Laura Owens was modeling on the stand. Why did her lawyer make her do that if she was traumatized? We could see her. That was so extra, making her stand up and like, let the court see how thin you are, girl. Show it off. Amanda M says they had a SWAT team at the courthouse, but tell you to call 911. Sure, that makes sense. He's trying to redeem his character, man. Zoe B says Laura was so terrified she was laughing and chatting with her attorney. Didn't look scared to me. And she started crying when she thought someone snickered in the court when she said it was minor perjury. That was minor. I just manipulated the whole medical record. Minor perjury. What's the problem? Stargazer Kawaii says she was in a courthouse, sure by police, and the court even called in more police and police dogs. Exactly. That's why it's usually an exception to be near the person for court. Exit sign says she wasn't distressed during her direct exam. She sure wasn't. And she wasn't during her cross either. She was real aggressive. Techfall 15 says BS. He was posting the entire time. His comments, his whole articles, you mean? Alex P says he was interneting nonstop on vacation. Exactly. I told her I would not have a lot of Wi-Fi, but I decided to email her, and then I filed a motion, and then I reviewed that I lost, and I had all of this Wi-Fi, but I'm claiming I have no Wi-Fi. Stargazer Quiet says he should have stayed in Europe. They should have left him. Oh my gosh. Star says he posted right in point to the ruling on social media. Island says he should call Dave to testify that Megan said that blank said that the judge dad said. Exactly. Is this hearsay? Absolutely. It's like double, triple hearsay at this point. Star says Dave is a comedian. He makes jokes. The other thing about it is like, how do we know that Gringas didn't set that person up to go and talk to Megan at this point? The way he's pointed it out, and it's like two people. Yeah, I doubt her daddy was just in there chopping it up. And there's like no bailiffs in the room to come forward and say, yeah, he was saying that. Like, come on, bro. Come on. Star says Dave was not in the courtroom and Megan didn't directly speak to the father. Exactly. It's hearsay. Sophie says to Star, 100% correct. And even Megan said that she was the one that said the word Joe. Exactly. Widget 81 says Gringas think Mata rushed her ruling because of him. Not really. She just wanted to get it out before the judicial conference, which was starting the next day. Yeah, he tries to make it seem like he sent the email and then all of a sudden she had a ruling rather than she had already been working on it. That was weird. Sophie says, Bree, please contact Megan Fox and do a collab with her. Y'all tell me, y'all, I'll be busy. Star says Bree and Megan are bosses. I'll see if we can do it. Y'all might just have to tag her and tell us to do it that way, because telling me to contact someone is probably never going to happen because I barely be ready for my own live stream, to be honest. South Florida Thrifter says, I'm so loving every minute of this. Thank you so much, as I was getting ready to fall asleep. So it also says Bree Megan 2024 for president. For sure. We can become president, girl. Sophie says, yes, the Planned Parenthood witness testified on it, I believe. I think that was the doctor. I don't think there was a separate person testifying. Coach Karen says, I am thinking the judge asked Laura Owens or the doctor during the hearing. It wasn't the doctor because we just watched the doctor But I'm thinking it might have come up on Laura's, but I'll have to double check. Kimmy Locker says, I did Control F and the word Sunday isn't in the hearing transcript at all. I wonder if there's something else. Like, wasn't there closed that day? Maybe you have the transcript, Kimmy. Maybe we can look at it. Coach Karen says she can verify hours. Really good grief. Yeah, exactly. I feel like she can. Nicholas Hall says, I'm doing a secret investigation too. Unless it's an urgent care or an ER, it ain't open on Sunday. That is also true. And like I said, she can pull from her common knowledge. Dustin, and like I said, there were typos and misstatements in the findings, so I wouldn't be surprised if she confused it. Tanya B, Destin to Be says, to me, all of this sounds like it's on an ad to promote my website. Exactly. Check out my website. That's where all the facts are. Good call, Tanya. South Florida Thrifter says, get him, Bree. I'm too tired for this, y'all. South Florida Thrifter says, Greengrass got a Bree in his bonnet. Yes. Coach Karen says, are we sure this dude isn't actually the firm's janitor? No, he owns it. And that's probably why he owns his own, because no one wants to deal with him. Star says, the only one who wins in this is Gringas' wallet. Yes, exactly. Nicholas Hall says, word on the street is he doesn't have malpractice insurance. That's not good, because he's doing a lot of malpracticing, in my opinion. Trying to call the court out for misconduct when you're misconducting. Star says, any judge will agree with the mountain of evidence. I agree. And a lot of people have come into this like me. I only came in maybe a month or two ago. And no, you're not convincing me. I heard the evidence. I heard it. South Florida Thrifter says, no, he didn't. Cheryl Reed says, that's so ridiculous. Nicholas Hall says, is insulting a judge and doxing her dad in a legal document acceptable lawyerly conduct? No. But Greengrass is going to do it. Star says, the picture Laura used in her TED Talk that showed she was abused by Mike and in the hospital was the same photo frame that she sent Mike because she was in the hospital for an abortion. Yeah, I read that too. And that does not surprise me. Stargazer Kawaii says his lawyer told him to agree to the restraining order. I think bad advice if true. It does look like it was an agreement versus something that the court ordered. It says that the parties agree that there can be a 2-year restraining order, which he probably just wanted to get it over. Or he probably wanted her to leave him alone. I've seen that happen before. I'll sign the restraining order as long as she leaves me alone. Okay. She sent it before the trip to Iceland and she claimed he abused her. South Florida Thrifter says the stream is so good, I will listen to it a few times. Is it? I feel like I've been stuttering the whole time. Like, I've been struggling. Widget 81 says, funny, no mention of her previous attorney who had to do a notice of candor telling the court that Laura lied to the court. Yeah, I've reviewed that. I don't think we've covered it on the channel though. Kimmy Locker says, don't forget to hit the like button if you hadn't already. Yes, of course, we already reached our like goal for the stream, but let's see, are we going to double it? No, we're not going to double it. We're at 131 and our like goal was 100, but that's okay. We still have fun. Chelsea B says, I'm so happy Clayton went after her. I watched the interview with her other victim and it was sad that he felt like he couldn't do anything. I agree. Widget 81 says, show how thin you are, but she slipped. Let me see. Show how thin you are, but she slipped up. She was 121 in May before getting pregnant, then 133 in October at 24 weeks pregnant. So her being 91 pounds means 30 pounds under her pre-pregnancy weight. Oh yeah, she did say that. They just weren't tying things together. They were not tying things together properly. Okay, thank you, Kimmy, for the transcript in the drive. Let me go ahead and get to what's his name, Clayton's response, and then we gonna go to bed. Okay. We are gonna go to bed before I get in trouble. I'm already gonna get in trouble. I've been on live stream too long, y'all. I said 11 o'clock, but I was just kidding. I did not mean that I was gonna be on this goddamn stream till 11 o'clock. Oh my gosh, Bree, come on, girl. Okay. Let's see. Can I get it? Ooh, I did it this time. Let's go. Tech savvy Bree. going on? Okay, so we are going to jump into Clayton's response. Okay, so we have Clayton's response to the request to change the judge for cause. Let's see what BS they point out. Boom. Here we go. Okay. Here we go. Pursuant to Rule 6.1, this is Clayton's response. Pursuant to Rule 6.1D1, respondent Clayton Echard hereby responds to petitioner Laura Owen's notice of change of judge for a cause filed July 8, 2024, and requests the court deny the notice as untimely. Respondent also objects to the salacious allegations contained in petitioner's filings, gross misrepresentations, reckless incendiary comments, and impugning the integrity of Judge Mata. Shout out. That was a strong opening. And insufficient ground to find a basis of the merits. What, Nick? I would have to give you your... No, I'm not going to pay you $650. I'm sorry. I just read it myself. No, I'm not paying you $650. But God dang, that was a strong opening. I'm assuming that Woodnick wrote it, but Isabel, if this is you, girl, snaps for you. Good job, because that was a strong opening. Deandra, you too. Sorry, I'm only referring to a couple of people. Here we go. So, and insufficient grounds to find a basis on the merits. But the court need not reach the sufficiency of the grounds because the notice is irredeemably time barred and inappropriately invoked. Agreed. And then I just want to read the footnote that talks about Judge Mata. Counsel comments that Judge Mata was trying to impress her father. Oh, they cited that one. Counsel comments that Judge Mata was trying to impress her father. Look at me, daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Because she's Michael Jackson. Like, that was a strong opening, y'all. That was for sure a strong opening. Response to the memorandum. Neither ARS 12409 nor the I can't talk. Nor is implementation via Rule 6. I gotta learn how to read. Okay, we're almost done, Bree. We're almost done. Neither the ARS nor the implementation via 6.1 permit change of judge by affidavit of bias and prejudice after final trial. History of common law preemptory challenge. This is a preemptory challenge, which means that you're looking to replace someone before the case ever gets started. Arizona long acknowledged a right to change judge upon filing an affidavit of reasonable belief of bias and prejudice. Early territorial statutes codified this right, and it was later implemented by procedural rules. Although the Supreme Court has refined the procedures, the right itself is not sourced from the procedural rule. Time limits for a challenge via affidavit of bias and prejudice. The relevant language of ARS 12409B5 as it exists today is functionally identical to the 1913 Civil Code provision, which itself gave form to its common law antecedent and 1887 Territorial Code provision. The court must reassign the action to another judge to preside at the trial. You hear that? To preside at the trial of the action upon the party filing an affidavit showing cause to believe in actual belief that she cannot obtain a fair and impartial trial on account of bias of the judge. Let me see. The language in the statute in 1915 was in all essential identical to the language of the statute today. The Echard decision reiterates that change of judge upon a timely filed affidavit, y'all, I'm trying to focus and I really can't. The Echard decision reiterates that change of judge upon a timely filed affidavit works automatically. As to a filing the affidavit in time, Echard approves and expands on Steffens and Allen, both of which endorse strict limits to filing before final trial. Steffens held that filing one day before trial did not waive the right, but Allen held that a party filing the affidavit after trial had already commenced did not act with diligence sufficient to require the trial court to take cognizance of her application. The party is not permitted to wait until he sees which way the decision is going to go before deciding whether to stay with or try to eliminate the judge who is hearing the matter. Nor is he permitted to wait until the judge has heard evidence on the merits, which will have to be resubmitted if another judge is substituted. Yeah. So Greengrass's interpretation of the rule, I'm saying if this was not rule 6, but 6.1, maybe this is an exception. Woodnick says, nah, it's not an exception. Petitioner's reading of Del Castillo versus Well is not supported. Procedural rules implementing the law did not create a separate and distinct remedy from the statute. It simply modified the procedures to be followed. Del Castillo expressly rejects the notion that procedural rules implementing 12409 create separate and distinct remedies. In fact, Rule 6.1 increases the burden by requiring the affiant to prove the sufficiency of cause to believe bias by an objective standard. The affidavit itself must have substantial merit. It does not. That's what he says. It does not expand statutory rights or create new ones. The court must simply reject the notice as time barred because it was filed after final trial and final judgment under Rule 78. Wherefore, respondent requests the following: an order rejecting the notice of change of judge, an order granting leave for respondent to file a supplemental affidavit of attorney's fees and costs, entering any further orders necessary and appropriate considering Rule 8.2a of the Arizona Rules of Professional Conduct. What I hope for this, they came in there strong, short, sweet, to the point, no lies detected. What I hope that happens with this is that Judge Mata responds and she gives them a reason. It's time barred. And your basis has no merits. That's what I hope she does. Just completely tell them, nah, bruh, we are not doing that. We're not doing it. Get it together. Okay? So let's have Bossy B bring us in for the end. Okay, we only got 2 comments. We got Stargazer Kawaii saying his paycheck is worth it for the wealthy like you. That isn't me. I can't do it. I can't do the $6.50 an hour, bro. Cannot do it. Give me Isabel. Give me Isabel, please. Nicholas Hall says, Winnick says we've been doing it this way since we arrived here in covered wagons and Model T. Yes. Why are you making new things up, Greengrass? Greengrass, you're making things up. Kimmy Lockett says, I love how short, sweet, and to the point the response was. Absolutely. They didn't need to bring up no lies. They didn't need to rewrite the story, rewrite the trial, all of the things, trying to convince the judge reviewing it that all of these things happen in trial when they didn't. I agree with you, Kimmy. Short and sweet and to the point. No need for convincing. You're late. You're done. And also let us file an update to our fee request because now he's incurred additional fees for me to read that nonsense. First of all, y'all, we didn't even read the whole thing on the stream. Made me read that nonsense and then now I got to respond to it. So y'all, that is all that I have for the live stream. We are currently 3 hours and 11 minutes into the live stream. Thank you for hanging in there with me. It has been a blast covering this case. Let me know what y'all think in the comments. We should have a video coming out, I'm hoping, over this weekend. I forgot to tell y'all in the beginning, but I did a flashback. I think I'm going to make a little series called From the Beginning. And we're going to be covering the Sarah Boone trial that's coming up in October. So we're going all the way back to the beginning with the complaint, and then we're going to cover some outrageous things that we found in the filings. So we got a couple of series coming out on the pre-recorded. So that's going to be the first pre-recorded From the Beginning. It's going to be the Sarah Boone trial. So hopefully you guys tune into that. I am hoping to release that on Sunday. Hoping, okay, to get that out to y'all. And it's not a long video. It's like Tuesday. It'll be a shorter video, not an hour or two. Greengrass has ended up being long because it was a bunch of nonsense. But Anyways, we're going to go ahead and premiere that next week. We will be streaming on Thursday next week. And then I hope to have another short video come out sometime next week as well. So feel free to let me know what y'all want to hear. I'm going to start making posts to ask what y'all want to hear about, because my mind be rattling and there's so many cases going on. I don't know what everybody wants to hear. Anyways, these cases, or not these cases, Clayton Echard and Laura Owen's case continues to be insane, and we're going to keep covering it so long as it's insane, but we are not going to cover it every single live stream or every single video. Thank y'all for hanging in there with me. I hope everyone has a wonderful weekend, and if you're in a hot location, I hope you are staying cool. I will see y'all all on the next live.